Councilmember Brodsky,
Present.
Councilmember Hong,
Present.
Councilmember Iglesias,
Present.
Councilmember Alude,
Present.
Councilmember Scher,
Present.
Councilmember Walensky,
Present.
and Director Kish.
Present.
Good morning, everyone. Welcome to the Fair Employment and Housing Council Civil Rights hearing on algorithms and bias. We know that algorithms are increasingly relied upon to make decisions that significantly impact lives in employment, housing, lending, and healthcare. Depending on the algorithm and the data used, these technologies risk perpetuating discrimination and inequality on the basis of race, disability, and many other protected characteristics in ways that are difficult to detect. I would like to welcome the public, and I also like to thank our noted experts who will be providing their testimony today. Before we do that, I would like to let you know that if you would like to ask any questions for members of the public, you could send an email to the following address, FEHCouncil, COUNCIL, @dfeh.ca.gov. You could post in the chat room or in the chat box, or wait until public comment to raise your hand and make comments. Without further ado, I'd like to also introduce my council members, Iglesias and Hong, who have been able to provide a wonderful civil rights hearing today. Council members?
Thank you very much. First, I want to express great appreciation for all of our panelists today. They're really leaders in the field, and we really appreciate their taking the time to prepare and make their presentations today. Unfortunately, due to family emergencies and other or unforeseen circumstances, we've had a few changes to the original program. Professor Pauline Kim of Washington University in St. Louis School of Law will be presenting instead of Jenny Yang on the first panel. And both of the panelists from the last session had to cancel, so we should be ending the hearing around 1:30. Based upon what happens today, the council may consider hosting another hearing on this subject in the future. Second, I want to thank DFEH staff, Adam Romero and Kara Broadfer for identifying and gathering these experts for us, as well as my co-council member, Helen Hong, for her hard work in helping plan the hearing. And third, thanks to everyone for attending this public hearing. So far, there is about 280 participants. We hope and believe that it will be both educational and useful for you and for the council's work on these very important issues. As we all know, artificial intelligence, including algorithmic decision-making, can do amazing and wonderful things. AI and algorithms have integrated seamlessly into our daily interactions. They provide instantaneous results and opportunities online, targeted advertisements, job postings, housing rentals, loan transactions, and much more. I use Google, Amazon, and numerous other businesses whose operations depend upon algorithms many times every day. But the efficiency and other advantages of artificial intelligence are not the whole story. What may be presented as a system that eliminates bias by taking humans out of the loop may itself be built on a foundation of bias. In fact, it has been well documented that artificial intelligence often operates in a biased or discriminatory way. This may come as news to some people. When I told my daughter about this hearing, she asked, if people are not allowed to discriminate, then why should computers be allowed to discriminate? Artificial intelligence, including algorithmic decision-making, is a technology already being used ubiquitously in almost every sphere of human activity. It can and will evolve, but at least now it is within humans' control. AI is not something that just happens to us. The evolution of it is not inevitable. Just because we can do something doesn't mean that we should. Asking the right questions about the data, design, and assessment of algorithmic decision-making can decrease discrimination. We can and should shape it to not harm people, including by not discriminating.
There are already developed and continually improving ways that corporations and entities using AI can de-bias it and reduce its potential for discrimination. For example, the nonprofit called Equal AI has published a checklist identifying how to do so. The Greenlining Institute has published a report with similar recommendations to promote transparency and accountability. And an organization called AI Global has set up the Responsible AI Community Portal, which is an evolving repository of reports, standards, models, government policies, data sets, and open software to inform and support responsible AI development. Discrimination is not inevitable. We think corporations, governments, and other entities using AI should take these steps on their own. However, if they do not do so, it is the responsibility of government, including this council, to regulate the use of AI to reduce its discriminatory effect and to hold them accountable for preventable discrimination. Since it is clear de-biasing is feasible, it is not unfair to corporations, government, or to other entities to hold them to a non-discrimination standard. In fact, just last week, the European Union just adopted regulations requiring some AI companies to provide regulators with proof of its safety, such as risk assessments and just documenting how technology is making decisions. We understand that technology always develops faster than law or ethics, and artificial intelligence is very complex, but that does not give government or the law a pass. Otherwise, AI may enable discriminatory practices on an extremely large scale. We need to be thoughtful, intelligent, careful, and critically minded, but not passive. And that is why we are here today. The DFEH staff has assembled a fantastic panel of experts to help us think through how the council can be involved in bolstering the application of California's anti-discrimination laws to artificial intelligence. Now, for the sake of time and to engage these experts, we'll be jumping right into the discussion. We are assuming that everyone has a general understanding of algorithms and AI, but to establish our baseline and understanding of today's topic, I will just provide a brief conceptual overview of algorithms and artificial intelligence defined by the AI Now Institute. Artificial intelligence, or AI, has many definitions, and it can include a wide range of methods and tools, including the use of algorithms for decision-making, machine learning, facial recognition, and natural language processing. An algorithm is a logic model behind any type of system that performs tasks or makes decisions based on inputs or data. Machine learning is a set of techniques and algorithms can be used to, quote, train a computer program to automatically recognize patterns in a set of data. Machine learning is the technique at the core of these new automated decision makings, making it difficult for humans to understand the logic behind these systems. Now, to get started, we are lucky to have, quite frankly, a national panel because of Zoom gives us the ability to really bring the best people across the country. And we are really pleased. Our first presenter is Aaron Rieke. He is a managing director at Upturn. Based in Washington, D.C., Upturn advances equity, justice in the design, governance, and the use of technology. Recently, Aaron's work has focused on the impact of new technologies on people's economic opportunity in domains including consumer finance, digital advertising, and public benefits. Before joining Upturn, Aaron served as an attorney at the Federal Trade Commission's Division of Privacy and Identity Protection, and was a Ron Plesser Fellow at the Center for Democracy and Technology.
All right, thank you so much for that introduction. I'm going to share my screen here. And while I do that, I just want to say that although I'm coming to you from DC today, I am formerly a California resident and a proud student of California Public Schools. So it's good to be here. All right, what I want to do today is really kind of set the stage for my fellow panelists, and then just give you a little bit of some policy thoughts at the end. My agenda for the next 15 or 20 minutes, I want to start just by talking about the hiring funnel, the whole hiring process, and how technology plays a role at each step along the way. I then want to describe two pieces of research that we've done here at Upturn. The first is a study of how machine learning can reproduce bias in job ads in online advertising environments. And I want to offer you that story just to really kind of cement and help you understand this notion of how bias can come out of machine learning, but also to emphasize the recruiting part of the process before applicants even submit their applications. I then want to talk about a new piece of research that will be public next week about what we've been seeing in entry-level online applications and the extent to which AI tools or even traditional tools are still kind of playing a role there. I want to say a few words about how as policymakers to think about the notions of auditing and de-biasing, which get thrown around a lot, but without a lot of detail. So I want to just offer a few tips there, and then I'll close with just some general thoughts targeted particularly at legislators and regulators who are thinking about these issues. To kick us off, I just want to ground us in this image of the hiring funnel. I think lots of people, when they think about technology and the hiring process, they think about a computer making a decision about who to hire. And it's more subtle and it's more complex than that, right? When we think about the hiring process, the first step is who even learns that a job exists in the first place? Who's even encouraged to apply, right? I think we all have a sense that there's an applicant pool. The sourcing stage, how job descriptions are written, how matching algorithms and advertising work, all of that matters in terms of building who even applies in the first place. Then once you've submitted an application, there's technologies that help screen qualifications and assessments. You move further down the funnel, you get to an interview, and finally selection, right? And I just want to emphasize that these are all kind of distinct steps of the process, and the kinds of technologies that you see at play at each of these steps may be quite different and diverse, but this all matters. And so I think I just want to open by saying, remember that the hiring process is pretty diverse, and the kinds of technology at play here are pretty diverse. We're not talking about one set of AI or one set of algorithms, but different technologies as they kind of apply at each of these steps. All right, the first little case study I want to give you is, I'm calling this machine learning and bias in sourcing. And I want to give you just kind of a stylized story that comes out of research we did on Facebook's advertising system. And for those of you that want to see the actual black and white paper, this is called Discrimination Through Optimization: How Facebook's Ad Delivery Can Lead to Skewed Outcomes. But let me go ahead and tell you the narrative and bring you along with what we found. And I hope that this not only gets you thinking about recruiting bias, but also gives you some intuition about how machine learning interacts with bias in the real world. So imagine that we had a global pandemic and you needed to hire a nanny to help out in the home while you gave presentations to California council members on hiring technologies. You might put out an advertisement on Facebook. And I want you to just start with, we put out a perfect advertisement in terms of its copy. It's not discriminatory in its images. It's not discriminatory in its text. It's not discriminatory in terms of where it links out to. It's a perfect advertisement on its face. Next thing I would do as an advertiser is target an audience of people on Facebook. And I want to do the right thing. And so I'm going to target everybody in the United States. And I'm going to set a lower age bound of 18 and an upper age bound. There is no upper age bound, 65 plus. So this is called the targeting step. And a lot of the headlines you've read about Facebook have to do with the targeting categories that it gives advertisers at this step of the process. That's not what I want to talk about today. Again, perfectly lovely advertisement. I've chosen my target audience to be about as broadly inclusive as I possibly can. What I want to talk about is how Facebook uses AI to choose who actually sees this ad, right? We've got a target audience here of probably a couple 100 million people. And Facebook, as the platform, has to make a decision about who's going to see our nanny share ad. And so I want to talk just for a moment about how that works. So now that I've targeted the ad competes with other advertisements to be shown, okay? As you scroll down your Facebook feed, about every 5th slot or so of content is an advertisement. Every time you hit one of those slots, a little auction happens in the background, right? So if this is Aaron scrolling down his feed, Facebook says, all right, it's time to show Aaron an ad. And they gather together all the advertisements for which I am in the target audience, which is thousands, right? And Facebook has to make a decision. Among those thousands, which one do we show Aaron? To make it simpler, let's just assume that there's the nanny share ad, there's a toothbrush ad, and a jewelry ad. Facebook doesn't just choose the highest bidder. Facebook says who's bidding the most on their ad, and which of these ads do we think Aaron is most likely to click on? Okay, and it's that second step. Which piece of content do we think this user is most likely to click on? That's where machine learning and AI comes in. Facebook is essentially asking itself, given everything we know about Aaron, his web browsing behavior, his behavior on the platform, his friend network, his demographic information on his profile, his past click patterns, what do we as Facebook think he's most likely to click on? And that prediction plays a huge role in the advertisements I actually see on my platform. So let me just skip to the next step here. At the end of the day, this is an ad, this is real gender demographics information for a daycare position that was targeting equally to men and women, equally of age groups across the country. As you can see, the ad went predominantly to women between the ages of 25 and 45 years old. If you were to put out a computer science programming position, you would see a skew that went to white men in their late 20s and early 30s. This is not because the advertiser is making wrong targeting decisions. This is not because any human being at Facebook is sifting these ads towards particular demographics. This is because there's a machine learning process that picks up patterns in past behavior and projects those forward. And so what you see when you put out recruiting advertisements or job postings into those environments is you see an exact reproduction, not an exact reproduction, but a reproduction of today's labor market conditions, which in many cases we're affirmatively trying to change as policymakers and as individual organizations. So this is an example, right, of how machine learning can pick up and perpetuate on bias. It's looking at past historical examples, making all kinds of correlations based on people's past behavior and projecting that forward. This is a headline that came out earlier this month that kind of is new research that adds on to the research I just explained, where the researchers controlled for qualifications. And they just double check to say, yeah, it doesn't matter how qualified the user is, you're still going to see these gender skews in advertisements. This is not a uniquely Facebook problem, right? I think we were able to do this research on Facebook and produce these empirical results because of some particular features of the analytics we were able to get back as an advertiser. But any system that runs on machine learning without intervention is going to reproduce that problem, right? Where that problem is that ads are going to go to the quote unquote usual suspects. And I want to just add one last note on this, which is it does not help very much, if at all, to remove demographic information from that data set. Right? If you put out a country music ad on Facebook, it will go to virtually all white users and no black users. And if you put out a hip hop ad on Facebook, it will go to predominantly black users and few white users, despite the fact that Facebook doesn't maintain explicit data on its users' race. Right? Once you get so many data points out there, you let machine learning loose on that, and it's very good about honing in on demographic groups when those demographic groups are predictive of an outcome. So I'd encourage you to go look at that paper. I think it's a great example of the way that bias can arise in AI in a real world setting. And I think it ties to hiring technologies because job recruiting runs on this in many ways today. Okay, second little research snippet here. I want to bring us back down to earth. That was a piece where we created an empirical kind of experiment on a large platform. In the last year or two here at Upturn, we submitted, let me see, get my text here. We submitted online applications to 15 large hourly employers in the Washington, D.C. metro area. The Home Depots, the Walmarts, the CVSs, large entry-level providers of hourly jobs. And we were curious, you know, given all the headlines we've seen about facial analysis technology, about AI assessments, what would we see as researchers walking through these application processes, using all the tools at our disposal as outsiders to try to ascertain what's going on? I want to give you a few findings, just high-level findings. The first is that despite the hearing we're having today, major employers are still using traditional selection procedures at scale, right? Including some pretty bonkers personality tests, even as they adopt some truly new machine learning and AI-based technologies. And I want to encourage you, when you think about algorithms and AI, to think about the way that just basic information technology can scale out pretty bad practices that are not new on their face, right? Employers use applicant tracking systems, which are these big pieces of enterprise software that facilitate their application process. There's nothing wrong with applicant tracking systems, but they're kind of this mix and match container for lots of different assessments and products that can be plugged in along the way. And so there's a lot of experimentation, a lot of new companies offering kind of ways to plug into those applicant tracking systems. And this is really a mix of old and new technology. And so as you think about how technology is changing the hiring process, don't forget to give a fresh look at things that seem pretty familiar on their face. Gosh, employers just never give candidates meaningful feedback about anything in the application process, right? It was virtually never that an application told us that we had failed an assessment, that our qualifications didn't match to the requirements, that our schedule didn't match with the requirements. The feedback was just about zero. And I think that makes it really, really hard for individuals to file complaints and vindicate their legal rights, right? Not only are the technologies and the analysis invisible, but any indication about even what step you might have been rejected at is invisible. And then I just want to say, as someone that kind of led up a computer science team and a policy team doing this experiment, there are just hard limits to what we can see from the outside, right? And so I think there really is a need for proactive oversight from government, because there's just a limit to what we can see as researchers. I want to just show you a couple of the things that we saw as of months ago, right? This is a CVS personality test, one of 70 questions. The applicant is asked to rate how similar they find themselves to these statements. It is important to question authority versus if my manager tells me to do something, I always do it, right? I just want you to look at this question, keeping in mind that Amazon voted down a union a few weeks ago, right? And there's a long history of anti-union sentiment and personality tests. A few other examples. I can handle whatever comes my way versus some obstacles are too great to overcome. Most people can be trusted versus it is smart to question people's intentions. I mean, some of these tests were in excess of 100 questions like these. And I just want to ground us in the fact that these are entry-level hourly jobs that people need to survive. I'm not an IO psychologist. I don't claim to have expertise in validity and assessment in this sense. But I put these questions before you because this ain't AI, but technology is putting this out in a big way, right? And we saw a lot of this. And I think that as we look at AI, it would be a shame not to revisit the extent to which these kinds of questions are job related and the extent to which these kinds of questions might especially impact people with disabilities. And so that's the one note I want to leave you on. I will, pass along our research about those application processes and what we saw. But I think the headline I want you to take away is we saw a lot less fancy new AI and a lot more stuff like's on the screen. With the caveat that, of course, we can't see the analytics on the background that the employer is doing. Okay. Changing gears one more time. I want to say a few words about auditing and de-biasing. You hear from a lot of technology vendors that their tools are de-biased or bias-free or audited, and there's all these positive terms surrounding those things. And I just want to give you just a very simple way to think about this. All tools, old and new, again, from the personality test to the new AI stuff, should be audited. What does that mean, though? And I just want you to think about this in two ways. There's quantitative auditing. This is the statistical auditing that we probably think about first and foremost, which is you have a big set of labeled demographic data and you check the outcomes, right? The 4/5 rule that's kind of associated with the uniform guidelines is an example of this quantitative auditing. It's a common tool, especially for race or gender, when you can label your data set, right? This is important, but I don't want us to lose sight of the importance of what I'm just going to call qualitative auditing here, right? And this is interrogating the actual variables and job relatedness that you're using to select applicants. And as I know Lydia will tell you a lot more about, quantitative auditing just is not that good for certain types of detecting certain types of discrimination, disability being chief among them, right? And so when we think about standards, or what are we asking of employers in the industry when we're thinking about auditing, I want you to think about the quantitative and qualitative distinction. And both are very important. I'm not trying to say one is bad and one is good, but I will say we have far too little qualitative auditing, far too little auditing that actually interrogates the meaning of the test and how it's likely to affect particular individuals that we can't label in a large data set. Last piece here, policy directions. I put this in kind of a cute do and don't list, and I thought in hindsight maybe that's a little directive, so don't take this the wrong way, but I just want to offer some tips, right? Like, as you think about regulatory policy, or as you talk with your friends at the legislature about how to deal with this, here are just some suggestions to guide those conversations. I want to start with the don'ts. Don't fixate on AI, and I don't mean to impugn this hearing at all. But I think it's really important to take a broad view of what we're talking about with hiring technologies, right? Facial analysis, assessments built using AI and machine learning, the job boards that optimize based on machine learning, that's all important, right? And that's all new and different, and that should invigorate us to look more closely at these technologies. But gosh, personality tests and commonplace like applicant tracking system features, they need scrutiny too. Like, don't think that anything that's been around for a while is a solved problem, right? And if anything, some crappy old dusty personality test is now being shot out to hundreds of thousands of people using like standard IT, right? So I think of technology as both scaling old bad practices and potentially creating new bad practices. Don't tailor your solutions just to the definition of AI that was offered at the beginning of this hearing. Don't focus exclusively on statistical auditing to the detriment of other forms of bias examinations. I think that any bill or any set of guidance that talks about auditing needs to be addressing what's quantitatively feasible, but also pushing for more of this hard qualitative work that I talked about earlier. Don't further entrench the uniform guidelines on employee selection procedures, please. This document is decades old, right? I know it's influential. I know it's familiar. It's decades old. It does not reflect even the current science in the APA world, right? Today, when APA people, when IO psychologists talk about validity, they talk about fairness and how minoritized groups are treated under those tests. The guidelines has none of that, right? The guidelines has a very brittle version of quantitative auditing, nothing that's great on the qualitative auditing side. This precedes lots of anti-discrimination law for people with disabilities. So, I think it's time to get ahead of those guidelines and think fresh and new and creatively until those are updated at the federal level. And finally, I don't mean to be snide about this, but don't settle for applicant transparency, right? Like, more applicant transparency would be good. Like I said, we saw virtually nothing when we did our application processes, but it's not going to help just to say, tell the applicant you're using AI. It's not going to help, right? So like, more disclosure to the applicant is good, but that can't be the core of the response. In my last minute here, some do's. Be proactive in your oversight to the greatest extent possible, right? I think one of the hardest things about this space is that you can't rely on applicant complaints to tell you what's going wrong, because the applicants don't have any information. All they know is that they did an application and they got no response, right? And I know that's challenging, and I'm much more familiar with the federal authorities, and it can be very challenging to be proactive, but to the extent you can, if you need to go to the legislature and say, we need some soft subpoena power to do research and studies and better develop our sense of the industry, do that, right? You can't wait on applicants. Require employers to show their anti-discrimination work. I think a really positive, if small, step would be public disclosure, or at least disclosure to US regulators, of these quantitative and qualitative audits. we need new standards and guidance on auditing and job relatedness. I mean, I looked for a definition of job relatedness in the California regs, and I didn't find it. It's a hard term to define, but I think now is a great time to take a fresh look at like what counts as a job related assessment, especially for these entry-level hourly jobs that are just critical to people's survival. And then finally, just don't forget about sourcing and recruiting. Not everyone has great authority in this area, but I think lots of the true big data machine learning stuff is happening at the sourcing and recruiting stage just as much as the assessment stage. So just a reminder about that part of the process. With that, thank you. I know there was a lot here. If anybody who's present today, whether you're whether you're on the council or a member of the public, have any questions, want more citations or information about any of this, I'm Aaron at upturn.org. And that's all for me.
Thank you so much, Aaron, for that. I'm sorry, in my excitement for this panel, I didn't introduce it completely. This is the employment panel. We have 3 distinguished speakers, and there'll be a half an hour starting around 11:15 for question and answers from the council and the public. And so forgive my faux pas. So moving along, we are now headed to Missouri, and we have the distinguished Professor Pauline Kim. She is with the Washington University in St. Louis School of Law. She is a national expert on the law governing the workplace and has written widely on issues such as job security, employee privacy, employment discrimination, and judicial decision-making. Her current research focuses on the use of big data and artificial intelligence in the workplace and the implications of these technologies for employee privacy and anti-discrimination law. Professor Kim is the co-director of Washington University's Center for Empirical Research in the Law, and we are thrilled to have her. Professor Kim.
Great, thank you so much. Let me just share my screen here so I can get my slides up. Thank you for this opportunity to testify. I think that these are really important issues, and I'm delighted that they're getting more and more attention. Aaron talked about particularly about issues regarding the use of algorithms and their influence over the sourcing and recruitment process. And I think that's incredibly important because those processes are what allows applicants to get information about jobs. But I'm going to kind of pick up, I think, at the next step and focus on how algorithms are used throughout the employment lifecycle once candidates have actually made contact with a firm. And in doing so, I'm going to focus my remarks primarily on aspects of race and sex discrimination. Partly that's just for ease of reference, but also because many of the examples that are available involve these types of discrimination. Now, obviously, there are other forms of discrimination that are also problematic. In particular, a lot of these technologies affect individuals with disabilities. And I think Lydia is going to be talking more about those issues. I just want to kind of mention them here, but because she'll be talking about them, I'm going to focus more on my, my comments on race and gender. So from the first contact that workers make with an employer can begin collecting data about workers. And they can do that through collecting information from the interface, the online interface, and the way in which applicants interact with that, or by scraping information from resumes. There are applications that offer employers the ability to collect data on voice and facial expressions through video interviews. There are some applications that require applicants to play games, play video games. And in each of these interactions, information can be digitized, broken down, and captured in hundreds or even thousands of data points. And all of that data can be analyzed and used to screen out applicants or to rate them and recommend who should be hired. Now, once the employment relationship is formed, employers can further engage in extensive monitoring of their employees. There are technologies like GPS, Bluetooth, wearable technologies, computer monitoring, All of these permit employers to collect an enormous amount of highly granular data about their workers, their physical location, their bodily movements, their online activities, and their interactions with others throughout the day. These data can be used to measure productivity, set compensation levels, or to discipline or even terminate current employees. All of this data that's being collected can be analyzed and used to make predictions about individual workers in order to inform the employer's personnel decisions. So Helen gave a really, I think, useful summary at the outset about what we mean when we talk about AI and algorithms. I want to step back and go into a little bit more detail about how these models are created. So when we have these predictive algorithms, they typically start with training data, lots and lots of data about, when we're talking about employment, basically lots of data about lots of different workers. And that data is fed into a computer which uses machine learning techniques to analyze the data. These are sophisticated computer techniques that look at the data in order to uncover patterns which are in the data that aren't apparent to a human who is just looking at it. And those patterns become the basis for a predictive model. Very often, this part of the process is one that is done by a third-party vendor who then sells the application to an employer. So that model, which is created through this machine learning process, is then deployed in the workplace by the employer. So for example, an employer might have an applicant. The employer will take data about that applicant. This is a new case. Feed it into the model, and then the model, based on the patterns it has observed in the past, will make some kind of a prediction about that individual. Are they going to be a good employee? Should they be screened out? Should they be hired? And so on. So there are a couple important points here about the technology. One of the key points here is that this question of what is to be predicted is a really important one, and one that tends to get overlooked. And I think this goes back to Erin's point about the importance of qualitative auditing. In the employment context, it turns out that asking that question, what should we predict, is kind of a challenging one, because employers want to predict things like who's going to make the best employee, or which of our current employees will be most successful if they're promoted. But a target like best employee or most successful can't be directly measured. And the computer needs something that it can quantify, that it can feed in as a form of data. And so these tools are usually substituting something else to predict, usually just basically using the data that's available to it. So for example, an algorithm might predict which workers are most likely to have been hired in the past, or which are predicted to get higher ratings by supervisors. And this choice of what to predict can have significant effects on who gets access to opportunities. The machine learning models here, as I said, are engaged in pattern finding. And very often that process is not informed by careful study as to what factors are actually relevant to doing a job. Instead, the computer is taking advantage of whatever data is available and just looking for the patterns that are visible in that data. And so as a result, what a model will predict will depend very heavily on the data it has been exposed to. In other words, the training data. So there are several well-known examples of hiring algorithms that have been found to have discriminatory effects. One of them involved a tool that was created by Amazon. Amazon was trying to create an algorithm that would screen resumes to identify the best candidate for software developer positions. It discovered that the model systematically downgraded the resumes of women, penalizing candidates who had things on their resume that indicated gender, like women's chess club captain, or individuals who graduated from certain women's colleges. Another example was an employer who wanted to predict which employees, which applicants were most likely to stay on the job if they were hired. And this particular algorithm found that the distance between an employee's home and work was a strong predictor of longevity on the job. The vendor in this case recognized that there was a potential for racial discrimination given patterns of housing segregation in the community and decided not to use that particular variable. So what went wrong in these cases? Or to pose the question more generally, how is it that algorithms can end up discriminating? It's possible that an employer or a vendor intentionally discriminates. In these two examples, there was no evidence of that. And in fact, in both cases, they stopped using the algorithm when the bias was discovered. So while this is theoretically possible, I think this is less of a concern. What's more likely is that these biases will creep in unintended ways. So one of the ways this can happen is through biased data. To return to the Amazon example, it's possible that they used supervisor ratings to identify the best software developers that they had. And perhaps those ratings were biased against women due to prejudice or maybe simply cognitive or implicit biases of the supervisors. And if so, then any model built using those supervisor ratings would reproduce those same biases. In the Amazon case, we do know that the data they used to train the model was not representative of the population. They used data about the company's past hires to try to predict who would be good hires in the future. But because their current software developers were overwhelmingly male, the model learned that it should find male software developers. There are other forms of data problems that can also lead to bias. I won't spend the time now to go through them, but just to be aware, there are multiple different sources of bias that can affect these models. And so I want to make clear, algorithms, not all algorithms are discriminatory. It is possible that some of them can be more fair and less biased than humans. We certainly know that humans can be biased in making these kinds of judgments, but there is also a concern that algorithms can discriminate. And these risks exist for all algorithms, but in particular, there are concerns in the employment context. What are those reasons for concern? Well, one of them is the point that I made earlier, that these algorithms are often just pattern finding. And what this means is that the predictions that they are making may be based on purely correlational factors, not causal ones. There's an example of a study in the UK that found that liking curly fries on Facebook was highly correlated with higher intelligence. Now, they didn't use this to do hiring, but you can imagine somebody trying to build a model based on social media activity, just looking for patterns and not paying attention to what is actually feeding into the model, and ending up with a system that makes a prediction based on something as arbitrary as whether they liked curly fries. Another problem with these models is their opacity. There's been some reference to that earlier. These are incredibly complex models. Sometimes it's difficult to explain exactly what factors are influencing the outcome or affecting the predictions that are made about particular individuals. One of the things that you'll sometimes hear is people who are enthusiastic about AI will say, well, we don't really need to worry if there are errors because these models learn over time. You feed in additional data and they'll just keep improving over time. The problem with that is that it assumes that all of these errors are being observed and can be fed back into the model. But once you're actually deploying a model in a situation like this, where an employer is relying on it to make hiring decisions, there may be instances where qualified applicants are being turned away, and they're perfectly capable of doing the job, but their error is not being observed. And so that kind of information can't be fed back into the system to try to improve its predictions. So given these risks, what can or should the law do about it? I want to start by saying there are things that existing law can do, right? We have a theory of disparate impact in both federal law and in California state law. I've got the definition up here. This disparate impact theory will cover many instances of biased algorithms. When they are having an adverse impact on a group, the employer should then bear the burden of justifying the use of that algorithm. I understand in California, you've adopted the uniform guidelines Erin has said a few words about that. I'll come back to that in a minute as well. But you also have this really nice definition of business necessity. But even though disparate impact law would seem to apply to these situations, they pose a number of challenges. These new technologies pose a number of challenges for existing anti-discrimination law. The first two, I think, really go to the things that Erin was talking about. Given the role of algorithms in the recruitment and sourcing phase, it's not clear the extent to which existing anti-discrimination law can address some of those problems, because the existing law really focuses on the employer, not so much on how applicants get to the employer. And so there's a challenge in addressing the role of these platform intermediaries. There's also some challenge because it's hard to know now who is an applicant or who should be counted as an applicant if the information that they're getting about jobs is being filtered through these algorithms. And who counts as an applicant might affect how we determine whether there's a disparate impact or not. So these are sort of new questions that are raised by the role of algorithms in sharing information about job opportunities at the sourcing stage. There's also this issue of what does job relatedness mean? What does this defensive job relatedness mean when employers may be relying on an algorithm that itself turns on an unexplained correlation? And then again, because part of the defense of an employer is supposed to be identifying job relatedness and business necessity, how does that apply in a situation where we have models that are very opaque and it's very difficult to identify or articulate a particular justification? So there are also practical challenges. I'm going to kind of skip through these because I think Erin covered them really well in terms of the lack of information that's available to applicants and employees about the data that's being collected about them and how it's being used in these models. I think I would just emphasize the fourth one here, which is even if individual employees and applicants get this information, in order to understand if there's some kind of discriminatory impact going on, in other words, in order to see whether or not there are systemic effects, you need to look at systemic data. So an individual who's getting information about their own particular case isn't going to be able to see those systemic effects. What to do moving forward? I guess I'm going to start with some cautions too. I'm not stating them as don'ts, but maybe cautions in this area. I think the first thing I would just say generally is beware of unintended consequences. One of the first reactions people had when they first learned that algorithms could be biased was to say, well, let's just prohibit employers from using any information about race or gender or other protected characteristics when they're building these algorithms. We'll just prohibit use of protected characteristics, that'll solve the problem. But as Erin's studies have shown and numerous other studies have confirmed that removing information about race and sex will not prevent bias on those bases. There are lots of other information in a highly data-rich set of information that would allow the computer to infer those characteristics. And if information about race and sex is removed, it will just make it harder to try to detect when bias is occurring, when there are these systemic effects. I think the other thing to keep in mind is the technology here is changing very rapidly. And even though there are, and so in both a positive and a negative sense, right? Computer scientists are working very hard to find ways to de-bias algorithms. At the same time, the techniques they're coming up with are often untested and can themselves sometimes have unintended consequences. So I think there's a tendency to want to focus on what looks like a best practice today, but those best practices may become obsolete in the future, or they may even turn out to be regressive in the sense that they have harms that were not initially intended or detected. So the caution is, I think, to be wary of jumping in too quickly to try to change the law in radically different ways. There is a risk, I think, of legislating too soon in a way that the law would end up prematurely locking into place some kind of a suboptimal solution. Having said that, I think there are some legal interpretive issues that, even given current law, could be addressed that would be helpful in moving forward. One is to encourage the preservation of sensitive data for purposes of auditing and study. The second is to deal with this question of what does correlation mean? Is that enough to show job relatedness? I think that the definition of job relatedness could be interpreted in a way that mere correlation wouldn't satisfy that. I think that the employer burden could be clarified here when they're relying on algorithms because they're the ones that have the data initially, at least. They should bear the burden of showing that the techniques that they have used to build the algorithm have made it statistically valid, and that this again goes to the qualitative auditing, right? That what they are predicting here is substantively meaningful. And then finally, again, echoing Erin's earlier comments, I would say that you might consider updating the guidance on validation. Those uniform guidance was created in the 1970s. It was based on very different technology, very different methodologies, and it might be time to take a look to see if the guidance could be updated. Okay, and then here's some other thoughts about things that could be done moving forward. And I say that these are short-term, emphasize short-term, because I don't think that these really solve the problems that we're facing, but these are steps that could be taken in order to move forward so that the agency is in a better position to discern what longer-term solutions might look like. Really important, I think, is building technical capability and expertise. There are a lot of initiatives that are now happening local, state, and federal level. We heard about things that are happening in the European Union where there are initiatives to try to regulate the use of AI. And I think it's really important that an agency with expertise on how these things play out in the employment field has a voice in those conversations, because a lot of that regulation is just sort of generic to the use of AI across many different areas. Use your powers to the extent you have them to engage in data collection, technical studies. Use those powers to try to increase transparency about what's going on and access to data. Facilitate auditing of those systems by third parties. I have little asterisks here because I would like to point you to the civil rights principles that were developed by the Leadership Conference. They talk about many of these things. I thought that they were very helpful. I think that a key issue, and I know this is probably something you have been thinking about and there's no easy answer, but diversifying the tech industry seems to me really important here, because part of the blind spots that have arisen in some of these technologies has to do with who's sitting at the table when they're created. And seeing greater diversity in technology industries, I think, would make a real difference. And then finally, I think it's important to find ways to empower workers to figure out how they can help negotiate the impact of these technologies in the workplace on their own work environment through education, and also finding avenues for them to have greater voice in how these technologies are used. So I will stop there because I think I'm a little over time. Thanks.
Thank you, Professor Kim. You are exactly at time. Both of you have timed your presentations to 20 minutes to the second. So thank you so much. Now we move back to DC, where we are also fortunate to be joined by Lydia XZ Brown. They are the Policy Council with the Center for Democracy and Technology's Privacy and Data Project, focused on disability rights and algorithmic fairness and justice. Outside of their work at CDT, Lydia is an adjunct lecturer in disability studies at Georgetown University's Department of English, and the founding director of the Fund for Community Reparations for Autistic People of Color's Interdependence, Survival, and Empowerment. But prior to joining CDT, Lydia worked on disability rights and algorithmic fairness at Georgetown Law's Institute for Tech Law and Policy. Lydia.
Good morning, Helen. Thank you so much for inviting me to be here. On behalf of CDT, the Center for Democracy and Technology, I am grateful for the opportunity to testify about the potentially discriminatory effects of algorithms that employers are increasingly using in their hiring and other employment decisions. CDT's areas of focus include protecting and advancing the rights of workers with disabilities who are facing an accelerating push by employers and technology companies to use algorithms to automate key decisions in the workplace and the labor market. We commend the Department of Fair Employment and Housing Council for having the foresight to convene this hearing, while policymakers still have the opportunity to frame the public debate surrounding the use of such algorithms, which can dramatically impact the lives and careers of workers, particularly those from marginalized communities. Today, I will first describe some of the ways that algorithm-driven hiring tools discriminate against disabled people and why this discrimination is already illegal. Then I will discuss measures that the Council can take to improve enforcement of existing laws and to advance development of new regulations and legislation to strengthen protections for disabled workers. When you apply for a job today, an algorithm might decide if you get an interview or if you get hired. These hiring technologies, as already discussed, can include resume screening software, gamified assessments, recorded video interviews, and personality tests. An algorithm will interpret how a person does on these tests to decide if they should be hired, or at least if they should be advanced to the next stage of the hiring process. More and more employers are using these algorithm-driven hiring tools now, both for low-wage and for high-salary jobs. In 2017, about 33% of businesses globally reported using some form of AI for hiring and related HR functions. In another 2019 survey, that figure was 37%, and it's only continued to grow. While these tools can be appealing, they can worsen hiring disparities that contribute to high unemployment and poverty rates for disabled people. Last year, only 17.9% of disabled people were employed, while nearly 62% of non-disabled people were. The pandemic itself also increased employers' reliance on remote technologies like algorithm-driven hiring tools. Algorithm-driven hiring tools can create barriers for disabled people in two ways: through the formats they implement and through their selection criteria. CDT's report, published in the fall, explains how 4 different types of algorithm-driven hiring tools can discriminate against disabled people. Number 1, resume screening software. Resume screening software works by searching for an exclusive set of specific keywords that indicate certain characteristics. But the keywords aren't always clearly relevant to the advertised job. For example, a resume screening tool might be trained to search for terms like honor society or athletics. When most current employees share those experiences, those words are assumed to capture the range of qualities of current, presumptively successful employees. But those terms reflect opportunities that disabled people are less likely to have. Resume screening tools likely overlook other relevant and qualifying terms. So they really are looking for proxies for characteristics correlated with success, but they're not actually related to specific job performance. Resume screening software can also look for gaps in applicants' resumes. Disabled people are more likely to have employment gaps because of disability discrimination itself, chronic illnesses, homelessness, or even incarceration. Number 2, gamified assessments. These kind of assessments require applicants to play types of games that purportedly measure aptitudes like reaction time, impulsiveness, attention span, problem solving, risk taking, and decision making under pressure. Gamified assessments can outright exclude some disabled people while unfairly assessing others because of their physical design and because of what they're measuring. For example, people with color blindness literally couldn't complete a test that requires them to click on red and green dots. People who have ADD, obsessive compulsive disorder, anxiety, or other cognitive processing or mental health related disabilities, their processing speed will be affected, so will their decision making. But they may not affect their ability to actually perform the core functions of any given job. These tests also might not measure how a particular person would perform those job functions while receiving necessary and appropriate accommodations in the workplace. Number 3, video interviews. These recorded video interviews require applicants to record themselves answering interview questions using voice or facial analysis to evaluate their personality or their capabilities. These tools assume that successful employees will have a similar degree of eye contact, make similar facial expressions and body movements, speak in similar tones of voice, and even use similar vocabulary. But many autistic people and blind people don't make typical eye contact. Many people with cerebral palsy or Tourette syndrome make involuntary body movements. And some people with psychosocial disabilities will speak in a flat or slowed tone of voice, while many deaf people and many people with traumatic brain injuries, Down syndrome, or cerebral palsy have atypical sounding speech for other reasons, or don't use speech to communicate at all. Number 4, personality and IQ tests. These ask applicants to respond to a series of prompts that claim to use these responses to identify applicants' personality traits or analyze their intelligence. Both of these characteristics might actually be unrelated to the job somebody is applying for. Personality tests can measure traits such as openness, responsiveness, or life priorities or motivations. IQ tests will attempt to measure vocabulary and other cognitive traits. But people with major depression or bipolar might score low on optimism on a personality test, even though optimism is not necessary for good job performance in the vast majority of jobs. People with cognitive processing or mental health disabilities might have markedly different reaction times and might display emotions or personality traits differently than neurotypical people. And autistic people like me might fail tests of cultural fit because of differences in our affect and communication style, or we might fail tests that require us to match facial expressions to emotions. We have to understand that disability discrimination in algorithm-driven hiring tools is already illegal. Under the Americans with Disabilities Act, the ADA, employment selection tests can discriminate against people with disabilities in 3 ways, pertaining to inaccessible test formats, selection criteria that screen out based on disability, and pre-employment medical examinations. Algorithm-driven hiring tools can violate each of these rules. The first ADA provision prohibits employers from using inaccessible test formats without providing reasonable accommodations. Employers have to make sure that all applicants can take their hiring tests, whether or not they have a disability. If disabled people can't use a specific type of test because of the format in which it's provided, employers have to provide an alternative format or another type of reasonable accommodation to make that test usable. Algorithm-driven tools often require equipment or platforms that disabled applicants just can't use. The second ADA provision bans the use of selection criteria that tend to screen out disabled people, unless the employer demonstrates that the criteria are both job-related and consistent with business necessity, already outlined. Algorithm-driven hiring tools are trained on data derived from correlations between characteristics of an employer's current employees and their work performance. When a tool's selection criteria comes from those correlations, the tool disadvantages disabled applicants by measuring cultural fit or other characteristics that are not directly tied to essential job functions. Disabled people might demonstrate job-related qualities, but we might be screened out if our disabilities prevent us from satisfying criteria that are not job-related. Under the ADA, an employer that does use discriminatory selection criteria must not screen out a disabled applicant who could still perform the essential job functions with or without reasonable accommodations. But the standardization approach in many algorithm-driven tools simply does not allow for the individualized accommodation to which disabled workers are entitled. And the third ADA provision bans pre-employment medical examinations. Some personality tests have used methodologies originally designed for clinical diagnosis of mental health disabilities. Other hiring tests have just outright been conducted by medical professionals. And one vendor of hiring tools proposed attempting to affirmatively detect disability so as to adjust their results for bias. If employers are not permitted to use such examinations as part of the traditional application process, they should likewise not be permitted to use them simply by folding them into an automated selection procedure. The council's regulations parallel the ADA, but California also expands protections beyond the ADA's provisions, particularly through affirmative obligations for employers to provide reasonable accommodations. First, like the ADA, California requires employers to select and administer tests so as to ensure that a disabled applicant's test results reflect the characteristics the test claims to measure. But the state has also established employers, quote, affirmative duty to make reasonable accommodations, unquote, if the employer knows of the disability. This goes further than the ADA, rightfully putting the onus on employers to create and provide accommodations. Employers violate these requirements if they adopt tests that by design disadvantage disabled people without providing accommodations to mitigate those issues. Second, like the ADA, California allows discriminatory selection criteria if employers can establish job relatedness and business necessity, or if effective reasonable accommodations are available. But in California, it is clear that employers, not applicants, have the affirmative, explicit responsibility of proving that such alternatives are unavailable. The council's regulations require California employers to demonstrate that, quote, an alternative job-related test or criterion that does not discriminate against applicants or employees of disabilities is unavailable or would impose an undue hardship on the employer, unquote. Further, employers and vendors currently rely heavily on statistical analysis to audit their hiring tests. But the council has correctly recognized that statistical methods are not necessary to determine whether tests have disparate impacts on disabled applicants. Specifically, the regulations state that statistical comparisons between persons with disabilities and persons who are not disabled are not required to show that an individual with a disability or a class of individuals with disabilities is screened out by selection criteria. The Fair Employment and Housing Council should build on its regulatory framework to better equip employers to achieve compliance. And the department must apply and enforce existing authority to protect disabled workers' rights. The council's regulations clearly prohibit many of the discriminatory algorithmic tools marketed today. But the council could build on its existing regulations to clarify that employers' duty to use non-discriminatory selection procedures require proactive steps on their part to investigate and mitigate potential sources of discrimination against disabled workers. In many ways, the most important policy changes would extend and apply principles the council has already enunciated. The council, like the ADA, requires employers to avoid using tools that would unfairly screen out or tend to screen out any disabled worker, regardless of whether the discrimination occurs on a scale large enough to be statistically significant. And as of last year, the council's regulations recognize that such tools include automated selection criteria and other online application technology that has the effect of limiting or screening out on the basis of disability, medical condition, religion, or age. The council's regulations also require discriminatory technologies to provide a mechanism for requesting accommodations. Taken together, these regulations indicate that employers cannot evade the laws protecting disabled workers simply by conducting statistical tests or by citing a seemingly low number of adversely affected disabled people as a defense. The council should give these underlying principles explicit force and effect to ensure that disabled workers are neither dissuaded from applying nor unfairly disadvantaged if they do apply for an open position. We believe the council could accomplish this by extending employers' duties so that before they deploy a selection tool that tends to screen out people with disabilities, they must demonstrate that the tool is job related and consistent with business necessity and that no alternative selection procedures are available. New regulations have to require employers to proactively investigate each selection tool's design and identify all potential risks of disparate impact against disabled workers. They must identify effective potential accommodations, modifications to the tool, or alternative selection procedures altogether that would allow applicants with disabilities to compete on an equal basis for any jobs for which the tool is to be used. And they must provide effective accommodations, modifications, or alternative selection procedures to mitigate each potential source of discrimination. If no effective accommodation or modification is possible, and if no alternative selection procedure could be offered that would eliminate the source of discrimination, the employer should be prohibited from using the tool. These rules could and should be applied to all selection procedures that employers use. but they are particularly essential for algorithm-driven hiring tools because applicants often aren't aware how they're being assessed or even that they are being assessed by algorithms. The department's standards should, in short, recognize that there is no one-size-fits-all way to check compliance with the full panoply of employers' non-discrimination obligations under California law. Further, the council should also remove unfair barriers to holding employers accountable. Workers and advocates have no insight into the tool's training data, what the tools actually measure, how the tools produce their outputs, or how much these outputs influence the ultimate employment decision. To reduce the huge information disadvantage that workers currently face regarding the nature and impact of selection tools, the council should require that employers make the results of their design and impact audits public, or at a minimum, require employers to maintain records of such audits that the department can later review for compliance. The department and council should also use their platforms to educate employers and workers alike about the potential risk of disability discrimination that these tools pose. When the department receives complaints alleging discrimination related to algorithm-driven hiring tools, it should use its investigative authority to examine the nature of the tool at issue and the steps the employer took to ensure that it's fair to disabled workers and compliant with California law. But even in the absence of a worker complaint, the department has the authority to bring cases where appropriate to enforce state law through director's complaints. When the department becomes aware that an employer is using algorithm-driven tools that are likely to penalize disabled workers, it shouldn't hesitate to use the director's complaint authority to proactively investigate. The council's rule should also explicitly state how it will assess the legality of algorithm-driven hiring tools that have an adverse impact on disabled workers. Lastly, California must avoid harmful regulatory and legislative schemes. Many existing proposals regarding algorithm-driven employment decision tools in California and elsewhere do not account for the legal and ethical concerns that we've already described. Some are well-intentioned but incomplete. Others are likely intended to head off liability before serious enforcement and interpretations are issued. Major trends include: 1, proposals that require transparency but fall short of requiring meaningful, proactive, and ongoing examination of potential bias. 2, proposals that do not ensure that workers have sufficient prior notice about how the tools will evaluate them so that they can determine whether they can or should request accommodations or challenge possible discrimination. 3, proposals that focus exclusively on racial and gender discrimination, which neglects disability discrimination and disabled workers who are multiply marginalized, as well as discrimination based on age, sexual orientation, or minoritized religious affiliation. And 4, proposals that set low or ambiguous bars for compliance and provide safe harbors to employers and vendors who clear them. The state must reject proposals that disincentivize employers and vendors from proactively reducing all forms of bias in their tools. For example, a bill introduced in the legislature last session would have effectively given employers a license to discriminate against disabled workers. The bill would have provided immunity from civil rights lawsuits to employers who use pre-tested assessment technologies that meet requirements far less stringent than current laws against disability discrimination, which prohibit the use of tools that unfairly screen out any disabled worker. The state must also avoid legislative or regulatory proposals that create such safe harbors for employers who use tools that tend to screen out disabled workers. Employment selection procedures have never enjoyed this kind of protection before when they cause discriminatory outcomes. And safe harbors certainly should not be introduced in the face of new technologies that make it far more difficult to discern how discriminatory decisions were made. Additionally, employers and developers of algorithmic tools often invoke intellectual property rights that make such tools even harder to examine. Therefore, selection procedures certainly should not be held to a lower standard now than they were in previous generations, when the design process for employment tests was more transparent and the basis for the results more readily explainable. California has long led the nation in preserving and advancing the rights of disabled workers, and the state provides protections that go well beyond those of federal law and laws of other states. In the face of new threats to disabled workers' rights that algorithm-driven hiring tools pose, we urge the council to continue and further its policy leadership, using its power to enforce existing protections for disabled workers. The council should also issue new regulations and guidance where necessary to ensure that the adoption of innovative tools does not trample the rights, the livelihoods, and the dignity of disabled workers. Thank you for your time today.
Thank you, Lydia, X.E. Brown, Professor Kim, and Erin Rickey. We're going to open up for questions to be asked by council members. So if any council member has a question, please raise your hand. And I see Council Member Iglesias, followed by Council Member Brodsky. Go ahead, Council Member Brodsky.
I was just wondering if any, I am not aware of any lawsuits that have been filed, but are there any that are in the system now that are challenging algorithmic driven screening or hiring practices? I know that 21 years ago, I was part of a lawsuit, a class action against a company that used the MMPI, and we got it, we settled the case. But it seems to me that there is precedent for this kind of thing. And I'm just wondering whether there are any current cases that are pending in wending their way through the system.
Any of the panelists like to respond to that question?
I think that's a good question. I know for a fact, I mean, I talk with plaintiff side law firms about this a lot. And I know there's a lot of interest. I think factual development for complaints is a real challenge. And so I'm sure there are some, but no big ones that I'm aware of. But I can only expect they're coming. I guess is my short answer. I don't know if Lydia or Professor Kim has anything else to add.
So I believe there was a case. There are a couple cases that dealt with the online platform Facebook advertising issue, and then I believe there have been a couple cases that have dealt with more than a couple, right? That have dealt with the personality screens, where it's a little bit unclear how much of it is sort of old style personality testing as opposed to some of the new AI technologies, but. I don't know of any that have squarely challenged the use of algorithms, not in terms of the access issues, but in terms of the systemic discrimination. And I'm not surprised by that because it's just so difficult to get the information, right? The places where there have been a handful of lawsuits, it's either been because there's an access issue that is apparent to the applicant, right? There was one case involved personality tests where on the East Coast, where the young man who applied had a friend who worked at the employer and sort of got some background information on what was going on. And then the Facebook cases, because Facebook does make some things visible in terms of how ads are delivered. There's been at least the possibility of exploring that. But for the employer who uses a hiring screen, a private employer who's using some kind of an algorithmic hiring screen, it's just so difficult to get that information and to know even what's going on.
Thank you, Professor Kim. Councilmember Iglesias?
Yes, thank you very much, panelists. This was really excellent. I really appreciate it. My question has to do, or kind of a cluster of questions has to do with this issue of self-regulation by the companies versus regulation by government. And it appears that, you know, the companies that are doing this, they're on to the fact, most of them, I guess, or you can tell me how many, are onto the fact that they need to do some self-regulation. And what I'm wondering is, but as Professor Kim cautioned us, you know, in this ever evolving dynamic field, it's kind of a moving target. So I'm just wondering if any of the panelists have thoughts about how can the council and the legislature, if it's interested, approach regulation where this sort of, there's this self-regulation that's going on. How do we assess whether a company has done good self-assessment, and then how do we set standards that are beyond the self-regulation?
Do either of you want to go first? I can just say this. I mean, a couple comments on that. The first is that a lot of the evidence I see of self-regulation really fixates on the 4/5 standard. as it's associated with the uniform guidelines. And so I think there are companies trying a lot of new things, and I do believe that any employer using any kind of selection procedures is doing self-testing. But what I've seen really fixates on the quantitative testing, particularly of sex and race, against the 4/5 standard that's associated with the uniform guidelines. And so I think we need to push past that, right? And I think employers need to be thinking hard about new kinds of quantitative tests. And as I think we've all stressed, we do this hard question about design and job relatedness. You know, I think I don't have a solid answer to that, but one thing I just want to suggest is that I do wonder whether a legislative approach that required more transparent evidence of those activities, that is to say, hey, employers and vendors, we want to see publicly your auditing work. We want you to articulate the quantitative tests you've done. We want you to describe the qualitative auditing you've done. And we want you to talk about your consideration of less discriminatory alternatives. And I think just forcing more information out into the public domain could be a really positive first, but certainly not the last step.
This is Lydia. I would add and expand to that transparency occurs on two levels. And one that we alluded to and expanded a bit more in our written submission is ensuring that there is transparency to the public as to what employers are using, what kinds of tools they are using, what types of auditing they or vendors have gone through. And the other is disclosure to actual job applicants or candidates before the application process and during the application process, so that candidates actually have a chance to know what they are going to be assessed on, what the assessment consists of, or what the assessment requires them to do. And that provides some level of knowledge for individual job applicants, particularly for marginalized communities, to at least have a better sense of what is happening. And while I, for one, recognize that there is always going to be an enormous power differential between someone who is applying for a job and really just needs money to pay their bills and may not be in a position where they can attempt to bring a charge or a case against an employer that might be discriminating, having that knowledge is still essential. But requiring vendors and employers to provide information to the public and have that information be available for public scrutiny is an important part of transparency as well. Ultimately, we are hoping that the council would take a very proactive approach to examining whatever auditing standards any given employer or vendor might be using, because the stricter we can make those kinds of auditing requirements, then the better we would be able to minimize the risk of unlawful discrimination. And at the end of the day, when auditing is left entirely to closed door, opaque processes that vendors and employers can vouch for themselves on without any external oversight, either public oversight or regulatory oversight, that's when they can claim that their tools don't have bias in them, when we know that that's not true.
Thank you. Any other questions from council members?
Yeah, this is Dara.
Hi, Councilmember, sure, go ahead.
I'm trying, it seems like a challenge to craft a precise enough standard in the law to make audits meaningful and understandable. And I think that is certainly a goal that the council would like to consider. And I'm hoping as we move forward, folks will have more suggestions about that, but particularly about distinguishing between audits that do qualitative and quantitative assessments. And folks have talked about that a lot, and I'm not sure I totally understand completely the difference between a qualitative analysis of bias and a quantitative.
This is Lydia. I can explain a little bit about what that looks like in the disability context. A quantitative analysis for bias is like the 4/5 rule that many people have mentioned in our discussion today, that we consider largely to be very outdated and ineffective in analyzing for bias generally, but in particular for categories that can be very heterogeneous, like disability. Historically, the 4/5 rule was meant to indicate that if if discrimination was happening at a certain statistical amount against people from a particular marginalized, disenfranchised, or underrepresented group, then that would mean that there was evidence of disparate impact. But it can be very difficult to measure who belongs to a particular group, even for marginalization that might appear to be more readily definable. For example, if you are looking at discrimination on the basis of race, it can get complicated when you're considering people who are multiracial, someone who is mixed race, Black and Asian, or somebody who is in fact racially white, but belongs to an ethnic group that faces ethnic negative racialization, for example, white Latinx people. And when you look at other categories like gender, it can be even more complicated. I'm a non-binary trans person, which means that I don't fall into the category of either male or female. So if you were attempting to statistically audit in a quantitative way for bias on the basis of gender, it might be hard to capture people who fall into a category like mine. That data might also fail to capture trans people who are a binary gender, trans women and trans men, who've chosen not to disclose their status as trans at work or in the application process. And it might not capture people who entered into a data pool while publicly identifying with one gender and now have identified as a different gender, they've come out. And when we talk about disability, it's even more complicated and messy. There are so many different types of disabilities, and even within any given category of disability, so many infinite possible manifestations of how that disability might be experienced by a particular disabled person, that it would be incredibly difficult, if not impossible, to attempt to quantitatively or statistically analyze overall, are people with disabilities being kept out of job recruitment or of hiring in a particular employer's practices. Qualitative analysis, instead of looking at numbers or statistics, looks at the actual selection mechanisms. For example, when I talked about resume screening software as sometimes looking for gaps in people's resumes, a qualitative analysis might be able to recognize that looking for gaps in people's resumes will likely lead to disparate impact discrimination against whole groups of people. Anyone who might become pregnant or have child or elder care responsibilities might have gaps in their resume. A person who has undergone extensive medical procedures because of a disability or chronic illness might have a gap on their resume. Someone who served in the military might have a gap on their resume if they don't want to disclose their veteran status. Someone who's been incarcerated, who are statistically more likely to be people with disabilities and people of color and low-income people, right, may also have gaps on their resume because they were not employed while incarcerated and or do not want to disclose a job that they held while incarcerated on their resume. And so the requirement of looking for gaps in people's resumes that are, say, longer than 6 months at a time, a qualitative audit would be able to flag that criteria in a selection tool as likely to lead to biased outcomes and to disparate impact discrimination. Does that help to make sense?
Thank you. Yes.
I just want to speak briefly to the 4/5 rule, because I know it is something that people have sort of pointed to as, and I think the computer scientists, the technical people, are attracted to it because it's a rule they can operationalize, right? 4/5 rule, nice and clean, it's mathematical, they can operationalize it. But I think there's a fair amount of misunderstanding. First of all, it's not a rule even in the federal system, right? It is a rule of thumb that the federal agencies articulated in terms of their own enforcement priorities. But the guidelines make clear that you could have a situation where the 4/5 rule, there's the difference between two groups is either greater or lesser than 4/5, and that does not mean there's not discrimination or that there is discrimination. It was just meant to be a starting point for thinking about enforcement priorities. But the way courts have actually implemented the prima facie look at disparate impact does not use the 4/5 rule. I mean, there are a number of courts of appeals who say we do not use the 4/5 rule as a rule. We actually look at the underlying statistical data to try to figure out if there's an impact going on here that needs attention. So one of the reasons why the 4/5 rule is not a great rule of thumb as a rule is because, particularly when you scale up these systems, if you think about a 4/5 difference between two groups, that could permit quite a lot of discrimination to continue, right? When it's operating on a large scale. The other thing is with algorithms and large databases, it's fairly manipulable. You could do something like just shift the cutoff slightly in order to get in a few more people, and with the same algorithm, depending on where you set the cutoff, you might satisfy the 4/5 rule or you might violate that 4/5 ratio, right? So it's, even aside from all the complications that Lydia has talked about, right? It's just not a great rule for identifying when there is discrimination or not. It is a starting point, but not a rule. And so because it is, for that reason, I think there really needs to be caution in terms of trying to come up with some kind of hard and fast objective measure that employers can be given to say, like, okay, as long as I do that, I'm off the hook, right? So many of these tools, what their impact is really depends on how they play out in very specific workplaces and dealing with very different types of workers. And so I think it's important to be cautious in moving forward, not to fall back on something that is fairly mechanical and will lose a lot of that nuance and a lot of those risks of discrimination.
Thank you, Professor Kim. Councilmember Alute, you have a question or a comment?
Yes, I have a question. So I'm really interested in the sort of points that people have raised about the ways in which human bias may replicate in the job as relatedness assessments that you've seen. And I wonder if anyone has seen any helpful models or examples of actual sort of job-related assessments that do achieve the end that they're intended for.
This is Lydia. I like to give the example of hiring people for a truck driver position versus an accountant position in helping to illustrate what kinds of job assessments make sense and are not discriminatory to give to applicants. When you are assessing somebody for a job, the assessment needs to be related to the actual functions of the job. And if it is directly related to the actual functions of the job, it is possible for it to be discriminatory in a way that's not necessarily unlawful. If you're hiring someone to be a truck driver, to do delivery, to do cargo or unloading, or to transport people as part of your company's practices, it would not be unlawful discrimination to give a vision test or a driving test to applicants for this job. Because in order to drive a truck without autonomous vehicles being the norm, you need to be able to be sighted and to be able to drive that truck. That test would be discriminatory against many blind people, by definition, who cannot see, and if even may have some partial vision, as opposed to being totally blind, likely would not be able to see enough to drive a truck. That test is discriminatory, but it's not unlawful. It is necessary and related to the actual job functions of being the truck driver. But on the other hand, testing candidates for that position of truck driver on their optimism, or even on what their level of conscientiousness is, or what their exact reaction times are beyond their ability to drive and reaction times on the road, probably isn't related to the job. If you're testing reaction times on a computer game, that's very different than testing reaction times on the road. Now, if you're hiring somebody for an accounting position, does it actually matter if that person can pass a vision test? Because somebody could be a sighted accountant and very successful or bad at the job, or they might be a blind accountant and be very successful at the job or very bad at the job. But the ability to see in and of itself is not directly related to the core functions of the job of accountant. And when I think about what employers can do if they're thinking about how to assess candidates for a job, if they want to do that, I always come back to the question, is what you're testing for directly related to the skills that someone would need to have to actually perform that specific job? And if it isn't, if you can't necessarily articulate a reason why this test is testing a characteristic that is directly related to the job, then perhaps you don't need to use that assessment.
Councilmember Sandoval, you're on mute. Are you calling on me?
Yes, Director Kish.
Thank you. I have a narrow question focused on the sourcing stage of employment. And my focus on this from a government enforcement perspective is related to the fact that, of course, if you are excluded or have no idea that a job is available, you cannot file a complaint. So the complaint-based system of civil rights enforcement falls apart at this stage. And I'm wondering if the panelists have thoughts on a standard for what the labor force looks like in a case that's challenging a sourcing mechanism that is excluding certain folks. And I think Professor Kim phrased it as who counts as an applicant.
So my narrow answer to your narrow question is no. I don't have a good answer to that question of what data set to use as that measurement. I think all I can say is to validate that I do think that this is a perfect example of an issue you can only spot with systemic analysis, right? And it's been very, very hard for class action attorneys to challenge the exact practices I described in Facebook's advertising systems, in part because judges just don't seem very persuaded by how do you know you individually didn't get to see an ad? Like, how does that work? So, you know, I'll just close by saying, like, we can provide you kind of these sweeping demographic trends across different jobs and markets and demographics. I don't know what you use as a reference data set. I don't have that one solved yet.
Professor Kim, would you like to add anything?
So I guess my answer is no, I don't have an answer either. This is the challenge. So focusing on the hiring side, right? If you're trying to show disparate impact, you're either looking at the actual applicants who applied. That's problematic. People are getting filtered out before they actually apply. Or you're looking at labor market statistics, and you know that's still an avenue that's available, but figuring out sort of, there's all the challenges we've always had with trying to figure out what's the appropriate labor market, right, for benchmarking this kind of analysis. And I think it's just sort of amplified in this context where the employer may say, well, look, this is just who showed up and applied, right? And how do we know if that actually reflects what a quote neutral labor market, whatever that is, you know, would produce, or whether it's an artifact of this sourcing process. So other than to say, yeah, you've actually, you know, completely put your finger on a problem there, I'm not sure what the solution is. I do think it is helpful, though, to recognize that these two things they interact, right? And so even, I mean, that's a step forward, sort of recognizing that that's an issue, even though I don't know what the solution is.
Thank you, Professor Kim. We're going to open it up to public comment. I know that Councilman Hong and Councilor Brodsky, but we're going to open it up to public comment. Any public comments?
Chair Sandoval, Kimberly Bennion has raised their hand. And so I'm going to unmute you, Kimberly Bennion. And if anyone else, a member of the public, would like to speak, please press the your hand. It's like the hand function, the raise hand function. And I'm going to allow Kimberly to speak now.
Thank you.
No.
Hi, we can hear you.
Thank you so much. I appreciate the opportunity. My question is very simple, and it's something I put in the chat. Is this information on the hearing has been extremely valuable to hear everybody's information. It's just really been helpful. I'm wondering if the transcript is available, and if so, how to get a copy of it. I saw that the one of the presentations is available, but the transcript would be really helpful.
We will we will be posting the recording a video online in the next few days. So that will be available, and it includes closed captioning if you would find that helpful.
Very much so. Thank you very much. Appreciate it.
Thank you, Ms. Bennion. Do we have any other public comments?
We don't have anyone who has raised their hand, and no one over email. We have some public comments. Oh, we do have one person who has just raised their hand, TSEE. I'm going to allow you to talk now.
Thank you. Is there will the recording be on DFEH's website, or will we be sent a copy of it?
It will be on DFEH's website.
And how will it be described?
It will be in there's a list of the council member meetings, and it will be included there as a recording. But you could also feel free to reach out to one of us, either I or any of the presenters, and we could also get you additional information.
Yeah, I teach at Cal State Bakersfield, and I've got recruiting and selection class coming up in the fall. And may I use it in the classroom?
Sure, and feel free again to reach out with any additional questions.
Thank you. Bye.
Thank you. Any other public comments?
Chair Sandoval, we have one more. Vincent Lay. I'm going to unmute you now.
Hi, I had a question around the authority of the department to require these types of disclosures around, the reasonable business necessities. Is that something that the department can do for like all AI hiring providers in California, at least?
Director Kish, you want to respond to that one?
The council and the department in our rulemaking capacity do have jurisdiction over record keeping. So I think the question is an excellent one, and it's something that we will be looking at in terms of the extent of our authority to include this type of information under record keeping provisions. But there will be a lot of work to be done, both practically and legally, to understand what specific outcomes, regulatory outcomes, if any, might result from this hearing. But to the extent there is a requirement to keep or disclose information, it would likely fall under the record keeping authority of the department and council.
Thank you.
Thank you.
We have no additional hands raised for public comment at this time. I do believe Councilmember Brodsky had an announcement that she wanted to make. Oh, and we have one more public comment, which we should have time for.
Okay, great.
Dion Carter. I just unmuted.
There we go. Oh, hi, can you hear me?
Yes.
Thank you. I'd like to just ask, I'm a recent candidate and found a job within the last 4 weeks. And going back to the question of the assessments, I wanted to know who has jurisdiction over the assessments, because many times there's a lot of these job boards out there, and the job boards pick up the jobs that employers are posting out there. So is it the employer? Is it the job board? A big one is, I don't want to name them, there's several of them. And so they give these very extensive assessments and personality tests. And many times if you don't do well based upon a criteria that the applicant has no idea about, who, and again, as it was said several times, you don't get any feedback on it. Who's responsible? Where's the jurisdiction for that? Is it with the job boards that pick up those, that just kind of scrub them and pick up the jobs, or is it the employers before? Where would a candidate or an applicant go to in those cases?
This has to be a Professor Kim answer, right?
I was going to say that was for you, Erin. I think, this is one of the challenges, again, with this new technology is sometimes it's difficult to locate where the responsibility lies. I don't know. Because there are often multiple entities involved in creating these systems. There's the vendor who is maybe creating the test. It may be somebody else who's taking that data and doing an analysis and producing some kind of a model.
Right.
The platform itself might be doing some kind of screening or monitoring or making use of it, and the employer might be making use of it. So this is another one of those complications which makes it hard to immediately regulate in this area, right? I think one of the areas where additional information gathering and investigation by an agency would be incredibly helpful is to start to understand these systems better, right? Who are all the different players and how are they interacting, so that we can begin to identify where the responsibility for these decisions should lie.
Right.
And I think, to tack on to that, right? I mean, federal law, Title VII applies to employers and employment agencies, among other entities. And it sometimes, in my view, it's been kind of difficult to say like, hey, a Facebook or a LinkedIn or some other like big important recruiting platform is an employment agency. I don't think that there's an obvious natural fit to that definition. I won't speak for DFEH's authority, right? I think the question would be, in addition to employers, what are the other covered entities? And is that defined in a way that includes these various recruiting platforms?
I'd just like to add one point on this. I think the question on the one hand was a practical question: who do I turn to question or challenge?
Yes.
And I think that really depends on who might be involved, and we don't know in any given situation. But from a legal perspective, I will just note for the audience that the Fair Employment and Housing Act, which is our employment non-discrimination law in California, does have an aiding and abetting clause, which prohibits anyone from basically assisting anyone else in committing an act that would be or an action that would be a violation of the act. So that's not a direct answer to the question about, on a practical level, who do I turn to? But from a legal perspective, that type of liability is very little discussed, but available under California law.
Thank you.
Thank you. I want to make mention that we have received several written public comments that will be made part of the record, but in the interest of time, we will not be mentioning them here, though we are grateful for them. Also wanted to let you know that we will continue to receive written public comments, and you can send them via email at fehcouncil@dfeh.ca.gov. I know we're coming to an end to this panel. I would like to thank all the expert panelists for providing this critically important information. And finally, I know that our council member Brodsky has a comment to make before we end.
Just real quick, I first want to thank everybody for your incredible presentations. I've learned so much and I really appreciate it. And along those lines, it's such an interesting topic there. I just wanted to make an announcement of another a panel on which is entitled Algorithmic Discrimination in Hiring and Social Welfare, that's scheduled for May 6th. That's next week. And it's being put on by the Berkeley Center on Comparative Equality and Anti-Discrimination Law, in particular, the Disability Rights, Systemic Racism, and Digital Equality Working Group. And the URL for it is to register. I'll put it in the chat, but that's the easiest way to do it.
Thank you.
And Lydia is on that panel as well. So it'll be great.
Thank you, Councilmember. I have one more announcement. For those interested in receiving MCLE credit, they should also send an email to fehcouncil@dfeh.ca.gov with their bar number. Thank you, everyone. We're going to take a quick break and we'll be back at noon.
Gabriel, can you send out the email address fehcouncil@dfeh.ca.gov? We said DFEH Council and people are getting a bounce back.
FEH, right?
I think Julie just did that.
Okay.
No, sorry, I just replied to the panelists.
Oh.
Okay, I'll send it.
I'll send it out to everybody right now.
Okay. Welcome back, everyone. We have our second panel dealing with housing, lending, and healthcare. And before we talk to our panelists, I'll turn it over to my colleagues, Councilmember Iglesias and Councilmember Hong.
Hello, welcome back, everyone. Thank you for joining us for the second part. I have the pleasure and honor of introducing our 4 panelists for this session. The session will be an hour and a half long. Each panelist will speak for about 15 minutes, and then we'll have 30 minutes for questions and answers afterwards. So our first panelist is Maeve Elise Brown. She is the executive director and a founder of an organization called Housing and Economic Rights Advocates. She has 28 years of experience as a public interest attorney, including advocacy and litigation and administrative advocacy on behalf of tenants and homeowners, public benefits advocacy, community organizing, fair housing advocacy, community workshops, and trainings and technical assistance for professionals. She has organized and opened a community development credit union, designed and taught a course on mortgage lending and homeownership at UC Berkeley School of Law, and served for 5 years on the Consumer Financial Protection Bureau's Consumer Advisory Board, functioning in her last year as the chair. Thank you very much. Welcome, Maeve. Go ahead.
Great. Thank you so much for asking me to be here. Pleasure to see everybody, folks I can see. Many familiar names and some lovely familiar faces. So happy to share a few comments with the council and that you're having this important conversation. So housing and a little bit about the organization to kind of set some context for how it is we know what we know, we think we know what we know, and why we think it matters. So HERA provides Housing and Economic Rights Advocates provides free legal services to both low and moderate income residents across the state of California. We have a broad economic justice and anti-discrimination mission. Within that universe, which encompasses much, housing to us is key because it's key for good health. It's key for success of varying kinds for us as human beings. And so we look at debt and credit issues as they impact access to housing, and we look at fair housing issues, fair lending issues impacting people who are trying to access housing, who are trying to stay in their housing, who are trying to access financing as homeowners, and who are trying to stay in their homes as homeowners. So let me jump into question number. We were given some guiding questions, which is very helpful to stop the typical lawyerly dithering. So the first question was about some of the specific ways algorithmic decision-making can negatively impact lending. The use of algorithms can negatively impact lending through use of criteria that have the result of causing higher rates of denials or just higher costs of access to capital. And I am directing my remarks in this panel more into the fair lending context. But this happens in many different types of contexts. So the algorithm can have the impact either intentionally or unintentionally of high denial rates are costing the consumer more who's a member of a protected classification. Where you really see it in the use of algorithms is with the use of what appear to be facially neutral or what people might think are facially neutral decision-making criteria that have that probably unintended consequence of damaging the consumer. So industry as a whole does like to discuss artificial intelligence as if it's a true manifestation of the singularity. So for all you sci-fi fans out there who read Werner Vinge's commentary on that back in 1993, we ain't there. Who's programming the computers? We are. Who's deciding what the criteria are that the computer is going to use? We are. And even with the best of intentions, there are proxies for race and gender that appear facially neutral, but that end up having the impact of targeting one group of people or another. So, and it is true that an automated process can reduce lending costs, something that industry points to. And it is true that absent having a human look at us, observe our personal characteristics in the application process, that an automated process could, or an online process, automated process without a human's face-to-face involvement, could at least eliminate negative gut reactions based on personal characteristics. But the opposite is true. And in fact, when we speak of artificial intelligence, another component is machine learning, in which machines are designed to try to learn from the data, truly learn from the data that they have been gathering, and are learning, making decisions. Their decision-making will evolve over time in theory. The idea is for them to get smarter, but get smarter at what? Get smarter within the confines of how they've been designed. And honestly, nothing short of real world application of any algorithm is really going to tell us whether or not it is going to have a disparate impact on protected classification. So, and I believe one of the panelists today is going to speak of this study, but a UC Berkeley study found that both online lenders and face-to-face lenders, this was a 2019 study, were charging higher interest rates to African-American and Latino borrowers and making massively higher profits as a result. But it's also interesting, the study found that the fintech or financial technology algorithms, the online lenders were discriminating 40% less than the face-to-face lenders. Significant, but not a complete elimination of discrimination. So just as one of many examples. The fact that both face-to-face and online platforms discriminate, to me, is an unsurprising finding for some of the reasons that I noted above, but I also want to note that reliance on credit score is a generally accepted common component of assessments. and that credit scoring models are still one of the black boxes of American financial life. We know that if you're just going to look at the numbers, the score, that you're going to see differentials based on race and gender. And you will see that people of color, on average, may have lower credit scores. So really something that I think still remains to be unwound in this space that's critically important is the credit scoring modeling. And absent that, I think we're going to have a hard time having a really significant impact on negative on the directing of higher cost products, or straight up the denial of access to loans to protected classifications. This also builds on this builds on our history of discriminatory exclusion of households of color, women, and others from access to the credit markets. So it's no small issue, it's no small feat. And when I think about the foreclosure crisis, most recently, as something that had a massively disparate impact on people of color and immigrants, women, seniors, that is a credit impact that they're still trying to recover from. And when you're looking at credit scoring, those are just lost years. So as a group, African-American and Latino consumers do tend to have lower credit scores than Caucasians. But I also want to note credit scoring itself is fraught with errors, running a 5 to 20% error rate, according to the Consumer Financial Protection Bureau's research over the years. So in addition to having credit scoring models that are not sufficiently without sufficient information given to regulators, much less to the public, about exactly what the weighting is of different aspects of the modeling, and so that we can really find out what whether there are unintended consequences, particularly negative consequences for protected groups. You just have a system has a significant error rate, which could make a big difference in pricing for people. It's also not clear whether or not artificial intelligence can adequately consider all of the 3 C's of lending. Going back to the basics there, these are cash flow, character, and collateral. So lenders will still tell you, hey, these 3 C's matter to us. I'm not sure. I have concerns about how AI takes into consideration character, both to the good and to the bad. I think about People's Republic of China's social credit scoring system that's going on right now. That is not something that I want to see us moving towards, because who you hang out with becomes a matter of a part of your score, your social credit score, and that's seems like that would be lead us down a really unfortunate path of reiteration of decades worth of bias. Similarly, how do we have inclusionary lending practices if we don't find ways to deal with the squishiness of character as one of the 3 C's, the wonderful breadth of character when you're trying to determine to whom to give access to capital and how much it's going to cost. I think about some of the great research that the CFPB did back in the day, for example, on medical debt, and how medical debt was having a disproportionately negative effect on credit scores. And to the extent that there was significant credit scoring damage for older adults and people of color and women, a disproportionate impact on that group. And it was the great studying of that impact where people who are otherwise A-quality borrowers might still have medical debt. It might be the only ding on their credit. The thing about the high level extreme mechanization of the credit access process also is at some point, the the factors could become, in a sense, invisible. We could start to take them for granted. And so unpacking, to move on to the next questions that we were given, one of which was, what steps could companies and entities use in the algorithmic decision-making process to reduce the potential for bias? Well, conducting their own extensive modeling before product release, hiring a third party to also conduct extensive modeling before product release, bringing in third parties to review product and program data used within the algorithm, because, you know, to a carpenter, everything looks like a nail. For me as a lawyer, everything looks like, well, whatever it looks like. But so you want to get third parties who have different training to come into that fintech space to give their perspective on, hey, oh, wait a minute, did you know that this set of criteria here actually may tend to show that it's particularly Latinos who are going to pop up under this particular set of criteria. Really interesting. I missed the first panel, but I read about bias in the employment context too, where word use will tend to indicate that you have a woman's resume in front of you versus a man's resume in front of you. So it can be things that people just don't think about every day. As to the question of new regulations or revisions to existing regulations, what I would wish for is for a requirement for industry not only to use extensive modeling, but to provide the algorithm to regulators before product release, along with the modeling used and the results of that modeling. I see the need to beef up regulatory staffing and expertise to be able to go ahead and grok what those models' implications are. There has to be explainability is a term, not a permissible Scrabble word, I'm pretty sure, but it is a term that's being used in the context of algorithms, explainability, which kind of captures everything that you would want to know as a regulator, everything I'd want to know as an advocate, and the consumer would want to know too, would want to know that they're being subject to. The provider needs to be able to explain how the algorithms work and how factors work. The synergy of the algorithm is critically important, which is why you have to do modeling, because one at a time by themselves, facially neutral factors may seem like meh. Facially neutral, no big deal. Together, however, in practical use, there may be a synergistic effect that gives some unexpected outcomes. I also would really love to see regulations setting some careful parameters around the use of credit scoring and credit scoring models that can be used, and to see some venturing into that space in some fashion, and encouragement to the extent that we, affirmatively furthering fair, we have our affirmatively furthering fair housing duty. I'd like to see an affirmatively furthering fair access to credit kind of a standard, which to me also suggests baking in alternatives to traditional scoring models from the beginning in the introduction of products. I have probably over-talked, so I'm going to go ahead and stop there. And I submitted written comments. Thank you so much.
Thank you very much, Maeve. That was very helpful. I appreciate it. So our second panelist is Eric Dunn. He is the Director of Litigation at the National Housing Law Project, where he's a national expert on tenants' rights and consumer law issues, and known for high-impact advocacy on matters affecting subsidized housing tenants and families struggling to access housing because of criminal and eviction records. Eric's most important legal victories include Arroyo versus CoreLogic, Rental Property Solutions, LLC, which established that consumer reporting agencies are subject to the Fair Housing Act when they engage in tenant screening activities. Welcome, Eric. Please go ahead.
Thanks. Good afternoon. Thanks for having me. Of course, my expertise is in the area of rental admission screening, tenant screening. And I think when people sort of associate the concept of using algorithms to conduct tenant screening, the idea that comes to mind is we're going to use technology and we're going to use data and try to use that in some way to objectively choose better tenants and I guess avoid landlords having unsuccessful tenancies. But the reality of what algorithmic rental admission screening looks like is nothing like that. There was an industry study in 2017 that found that about 90 to 95% of landlords use some type of third-party tenant screening report. And usually these reports are not going to just provide a packet of information like they do in the past, and then the landlord would take that packet and look through it and decide for themselves, do I want to rent to this person? Instead, it's going to be a system of networked computers searching databases, pulling information that matches the rental applicant, which hopefully will actually belong to that rental applicant, and then processing it through an algorithm that applies the landlord's rental admission criteria. Machine reads the information, the background information about the applicant, applies the landlord's rental admission criteria through an algorithm, and then makes a decision of whether to admit that applicant or reject that applicant. And we would think that these criteria must be designed to predict, who's going to be a successful tenant and who's not, and filter out people who would be unsuccessful and accept the ones who would be. But in fact, I think people would be surprised to learn that the criteria that go into these algorithms, the criteria that are used to select tenants, are not designed with any sort of predictive evidence or predictive modeling in mind. This is unlike some of the other type of screening you may look at with credit modeling and insurance modeling, where large data sets are taken and potentially used to project a borrower's likelihood of defaulting on a loan or something. These are simply criteria chosen by landlords, usually from a menu of options provided by the screening company with no guidance as to how to choose them, or if there is guidance as to what their criteria should be, they're based on things like marketing. What are other companies in this space doing? How many years back are they looking for certain types of criminal records? Or do they automatically deny people with an eviction history, or do they exclude certain types of records, like maybe a dismissed case or something? It has nothing to do with any sort of data or evidence showing that tenants with certain types of records are less successful. It's just that's what the other companies are doing. So, one rationale I've heard is, well, we don't want to be the only landlord in town that accepts people with certain types of criminal records, because then all the people with that criminal record will come and live in our property. So we want to have the same screening company as our competitors. But that has nothing to do with choosing good tenants. And a lot of these criteria, the justification that landlords will advance are things like, well, this is just common sense, that people with criminal history are likely to be more dangerous than people without criminal history. Or it's just our experience that tells us that people that have eviction records are more likely to be bad tenants than people without eviction records. But even if that's true, there's no way of measuring it. There's no way of assessing how much more of a risk somebody with a criminal history might present, even if that's true, or how much more likely of a risk someone with an eviction record is to default in their rent or something than someone without. It's not just common sense. There needs to be some kind of evidentiary basis to establish these types of criteria, because somebody that has no criminal record can commit a crime for the first time, or maybe caught committing a crime for the first time, or somebody that's never been evicted before can be evicted for the first time. I think we're seeing that right now with COVID-19. At one point, we had close to 10 million US renter households behind in rent. An untold number of those families probably had never been evicted before, had never maybe even been late on a rent payment before, and all of a sudden they lose their job in a 100-year pandemic. Doesn't mean that that record, or that occurrence, is predictive of how they'll perform in the future. So I think when we start looking at solutions, to deal with some of the problems that algorithmic and automated type screening creates in the rental admission space, the place to start is requiring companies to have evidence to justify the criteria that they're putting in, that they can't just be doing this in the seat of the pants. It's not just based on things like common sense or our experience tells us we need to screen out people with this type of record or that type of record. And some of the harms that this creates are significant. One issue is that the criteria that landlords choose without evidence tend to be very backward looking, and it makes them sort of self-fulfilling prophecies. If you have an eviction record and you can't get housing, because it's very common for landlords to just categorically program their screening software either to automatically decline people with eviction records or to do it in more of a truly algorithmic fashion, where having a certain type of landlord-tenant record will saddle you with so many points that are count negatively towards your application, and then maybe if you have that plus any other thing, you might be denied. But people with eviction records get systematically denied housing. Where do they wind up? They wind up usually in less desirable properties with landlords that have to lower their criteria, that have, that can't be as selective. These tend to be landlords that don't take as good a care of their properties, tend to be properties in areas where there's fewer jobs and maybe more environmental hazards such as crime or literal environmental hazards, or lack of public services, transportation, and other things. And it sets people up for failure. If you have a predatory landlord who's charging exorbitant rents and not taking care of the property, but that's the only place that you can rent because the other properties won't accept you because of an eviction record, you may be more likely to fall behind in your rent again because you're paying more than you can afford, and you have other problems that you're having to deal with. And even if somebody did a study and said, well, people that have been evicted before have a higher likelihood of facing eviction again, why is that? Maybe the fact that they're frozen out of opportunities to get ahead contributes to those types of numbers. So there really needs to be legitimate, valid social science evidence to back up these types of things, and not just these sort of self-fulfilling prophecies that come from using common sense and our experience in the field. I don't think that this means we need to get rid of algorithmic type processes altogether. What I think it means is that automated screening and algorithmic processes should be used as more of a first pass. That if you have legitimate criteria and you have technology that can apply them more quickly and more objectively than human decision makers can do, and you can use those to run a background check on somebody, and if you don't find any reason to turn them down, they're in, fine, you're done. But if you do find that someone has a problematic record, somebody doesn't have a high enough score to meet your threshold for admission, then housing providers should provide somebody an opportunity to appeal that decision and have a human being who can take sort of a totality of circumstances, look at it and make an objective sort of, judgment-based decision about whether this person, has indicia of being likely a good tenant or not. If you have an eviction record and it was from COVID-19 and you lost your job unexpectedly, but you're back to work now and there's no other reason to think that that you wouldn't pay your rent and be a good tenant in the future, a human being can sort of make that distinction. A computer really can't. So using this type of screening as a first pass. And then I think what's also important is that the procedural rules that go along with using this type of screening are essential to making any kind of substantive protections really meaningful. Of course, when landlords have policies like automatically declining people with any kind of eviction record, or blanket bans on certain types of rental history, that certainly produces disparate racial and ethnic impacts among other effects on other protected classes. But you can't find out that you were denied, because of that some type of record that causes disparate impact, unless you can find out why you were denied housing. And so just a very simple change requiring landlords to disclose in a plain language written statement, if they denied your application, what the reasons were. It gives you a chance to go back and look and see, first of all, was I even denied for a reason that was consistent with the landlord's policy? And secondly, if I was, what's the evidence to support that type of criterion? And does it have a disparate impact, and can that impact be justified if it is? Most landlords will have some type of written rental admissions policy, but it's usually very vague. An application may be denied for any of the following reasons: damaged credit, eviction history, criminal records. But the way that these algorithmic systems work, you require much more detail. There's something like 10.5 million unique criminal offense descriptions in the US. So what that means is the same crime that somebody commits in one state might have a different name in another state, or a different categorization in another state. And when somebody's doing a 50-state criminal history search, they might find records belonging to people of various crimes, but they have different names. And you can't go to a landlord if you're a screening company and say, here's 10.5 million different types of criminal records. We want you to decide which of these ones you're going to screen for and which ones you're not. You have to try to narrow this down into manageable categories for the housing providers to choose from. And so, for instance, CoreLogic, I think, has 36 categories. Some companies have even fewer categories than that. But you're taking millions and millions of different types of criminal offenses, and you're putting them down into a small handful of categories. And what that means is there's a real opportunity to make mistakes. And a housing provider's policy might be, well, okay, for violent crimes against people, we're going to screen for up to 10 years. But for nonviolent property crimes, we're going to screen for shorter amount of time, and certain other crimes that have different look-back periods. Well, if your crime got put into the wrong category, you might be screened out improperly, because if it had been put in the right category, you might have gotten in. But tenants never get to see these detailed criteria. Which crime categories is the landlord looking at, and which crime category did the screening company put your record into? Did they put in the right one or the wrong one? What age did they assign to the offense? If you committed your crime on one day and then you were arrested a month later, and then you were charged, and then you had a trial 6 months after that, and then you were convicted after that, are they going by the date of the crime, the date of the arrest, the date of the trial, the date of the conviction? Those can make big differences in terms of how the look-back periods apply and who gets into housing. And rental applicants have no way of seeing how this information was sorted, classified, and filtered. And mistakes are very common in background checks of this kind. There haven't been any studies into the accuracy of tenant screening reports. And the previous panelist, Maeve Brown, had mentioned studies into the accuracy of financial credit reports. So this is where you have Capital One credit card has their computer system networked with the credit reporting agency, and once a month, the credit reporting agency downloads the payment records from Capital One. And maybe it's possible there can be some kind of mistake or glitch that way. And I think those studies have found between about 20 and 30% of reports have errors, even with that type of reporting. But with criminal background checks and eviction records, the errors are much easier to occur. And one big problem is that with an eviction record, for example, a landlord, when they file an eviction case against the tenant, they don't name they don't put in the tenant's birth date and social security number and other identifying information. All they put in is the tenant's name and their address. And sometimes that information doesn't even make it into the court's electronic system. And so when tenant screening companies search for eviction records, they can't match a record to a specific rental applicant using a date of birth and a social security number and all the other identifiers that might go into a financial credit report. They just match somebody based on their name and what county they live in, or what city they live in. And so if you live in the same city as somebody that had an eviction case filed against them, they might match that record to you. And we see these types of mistakes over and over and over again. And with criminal history, there's many more things that can go wrong. And so Giving tenants transparency into this process, being able to see what the landlord's screening policy is, being told the reason that you're denied for housing, and having an opportunity to go back and dispute a denial of housing, could really make this a much more fair process. That ability to challenge a denial needs to be meaningful. So people need to be told about it. They need to have an objective person who's not just rubber stamping the computer's decision. And you need to keep the rental property open and available while they're applying. Because if you go through some kind of appeal procedure, oh yeah, we made a mistake, we shouldn't have turned you down, but sorry, I already rented the place out. Good luck. That doesn't do anybody any good. So that's, I don't know how much time I have left.
You're at about time, so maybe finish up in a minute. Can you do that?
Sure, yeah. Just the last thing I wanted to mention is that with rental screening, I think one significant difference with rental screening from a lot of other types of screening is that when people apply for apartments, they usually have to pay a fee. And the fee isn't usually that much money when you compare it to how much rent costs, for example. The problem, though, is that if you get denied, you have to pay that fee again to apply somewhere else. If you get denied again, you got to pay it a third time and a fourth time. And this just deters people from even applying. I am convinced that these types of fees have significant racially and ethnically discriminatory effects in terms of steering people into substandard housing. Because studies have shown time and time again that Black women face eviction at substantially higher rates than any other demographic. That African Americans and Latinos face the highest rates of criminal justice involvement. That all these types of criteria that go into rental screening decisions and result in denials are distributed more heavily to protected class members. And they're deterred from applying by these fees. So another thing I would like to see is somebody study this and see if that's empirically true. Because if so, I think the practice of charging screening fees to even get into this process in the first place is another important thing to consider. But thank you very much.
Great, thank you very much. I really appreciate it. So I'm going to introduce our third panelist, Professor Robert Bartlett. He's a professor of law at UC Berkeley School of Law and the faculty co-director of the Berkeley Center for Law and Business. He's the co-author of the article Algorithmic Discrimination and Input Accountability under the Civil Rights Acts, which proposes a statistical test to apply to the design and review of the inputs used in any algorithmic decision-making process. He was also co-editor of Consumer Lending Discrimination in the FinTech Era, a recent study which found that both algorithms and face-to-face lenders charge higher interest rates to African American and Latino borrowers. Thank you very much, and go ahead, Professor Bartlett.
Great, thanks so much to the council for allowing me to present today. I have slides that I'll share. So today's remarks, with respect to the questions that were solicited, I'll focus primarily on questions one, negative impacts. What negative impacts can algorithmic decision-making machine learning have on protected classes of individuals, as well as what steps companies can do to minimize these negative effects in using AI. And then question 5 would be, well, how the California state could use its existing authority to minimize the adverse effects of algorithmic decision-making. So I'm going to divide my remarks into 3 categories. The first one is going to focus primarily on this first question of what can be some of the negative effects of algorithmic decision-making. And I'm going to refer to some of the findings in the paper that Councilmember Iglesias just referred to. Secondly, I'd like to sort of then pivot to some of the more proactive measures that both companies and the state could use under its existing authority, under federal existing authority actually, to try to regulate the disparate impact that algorithmic decision-making can have on protected classes. And then lastly, I want to turn my attention to what I think is maybe some low-hanging fruit as well for the state to consider, which is, I think, is sort of a misapplication of that is occurring for a lot of companies and how they are trying to self-comply with disparate impact liability measures. And so I'll sort of speak to that. Okay, so with respect to the first topic, I am a co-author on a paper with colleagues at the Haas School of Business, and we investigate interest rate differentials for minority borrowers for roughly 6 million GSE loans, that is Fannie Mae, Freddie Mac, and FHA mortgages, Federal Housing Administration mortgages that are issued between 2000 and 2015. And the primary finding that we have in this study is that minority borrowers pay, depending on the specification and the sort of subsample we're using on, but it's roughly 5 basis points more per year than non-minority borrowers for purchase mortgages for both GSE and FHA mortgages, and about 1.5 basis points more than non-minority borrowers for refinance mortgages across both GSE and FHA loans. When you aggregate the volume of mortgages that happen in this country, those numbers add up to quite a bit. So you can sort of back the envelope estimate, which is just maybe $450 million per year in extra interest that minority borrowers are paying because of what we think is likely to be impermissible discrimination. And that last point sort of raises maybe a broader question, which is, well, why do we think this reflects impermissible discrimination? And this has to do with how discrimination is defined under the Fair Housing Act, and just focusing sort of on unintentional discrimination, which would be regulated under the disparate impact theory. The way it works, of course, is that if there's a disparate impact, such as what we have found in the differences in rate, then of course the burden shifts to a lender to offer up a legitimate business justification for those differentials. In that justification has to be rooted in a business necessity that's acceptable to courts. That is, what's a necessity that can justify disparate outcomes across protected classifications. Courts have been very, very unified in saying that justification in the context of lending is creditworthiness. Okay, so you can have interest rates and exception and rejection rates differ by protected classification if it's because of differentials in creditworthiness. Other reasons for differing outcomes that don't relate to creditworthiness are therefore going to be legally problematic. Okay, so basically the only way that our observed differences can be justified is if they relate to differentials in credit risk. And it turns out within the GSE and FHA universe of loans, we're able to address what has been one of the largest obstacles for studies of discrimination in mortgage lending, which is what is someone's credit risk? Okay, that is in some sense sort of an unobservable characteristic of an individual borrower. But in this particular context, it's very unique in the sense that credit risk is assumed by the GSEs or by the FHA. And as a result, the GSEs have basically dictated that credit pricing is going to be a function of credit risk when credit risk is defined only by 2 variables. Okay, they price credit using basically a 2x2, or I guess you say an 8x8 matrix of credit score bucket and LTV bucket, loan to value bucket. Okay, so those are the 2 criteria that they care about for purposes of loan pricing. So we can observe that in the way that our data has been merged with other. We basically took the HMDA data, which provides information on some borrower characteristics such as demographic information, and then we merged that onto another set of data that allow us to sort of see the credit score and the loan to value for each borrower. So as between 2 individuals, one a minority borrower, one a non-minority borrower, who are in the same LTV credit score grid, there shouldn't be any differentials in credit pricing because all of credit risk has been observed. Similarly, with respect to FHA loans, these loans are insured against default by the Federal Housing Administration. So as a result, there's officially no risk-based pricing that happens with these loans, although in practice, it does appear that lenders often use LTV and credit score as well, and so we can apply the same framework to these loans as well. So just sort of visually to sort of show what we do, if you look at the top 2 grids, for instance, this is just a general histogram for on the left side at the top. This is just the law GSE interest rates on purchase mortgage, and you can sort of see that they kind of vary from 3% to sort of 6%, 7%, which makes sense during this time frame. On the right-hand side is the same for FHA interest rates. If we then basically look within grid, okay, so what we see in the bottom is that basically those differentials collapse dramatically. You can see that that basically 0 is basically the mean interest in a particular grid cell. We can see that the variation has dramatically collapsed. But if you notice, even in these histograms, the blue shaded bars are shifted slightly to the right. That's an indicator that even within grid, minority borrowers are paying more than non-minority borrowers, which is in some sense the core finding that we have. Now, of course, we run it through, we run a variety of different specifications to sort of deal with some of the differences, because there's a different grid for cash out refinance mortgages, for instance. We need to control for sort of time variation, the fact that interest rates change over time. But the point is that what you saw in that visual basically persists even in our regression specification. So I don't mean to sort of present too many numbers here, and I promise this is my only result I'm going to show. But the relevance of it for today is that we see that this result persists with respect to non-fintech platform lenders, sort of conventional lenders, as well as purely automated fintech lenders as well. Okay, so both types of lenders, fintech, non-fintech, seem to be engaging in this practice. Naturally, this raises the question: well, why is that the case in the fintech? They can't observe the borrower's classification. It's impermissible to code something that would do that. Here is a potential theory, and we know that in the non-fintech world, that when a borrower walks in the door of a bank, there's some sense of how much shopping, what type of competitive offer will have to be offered to that borrower. So Susan Woodard has a study of that in the FHA context, and we can imagine why that would make sense. That lenders who make more money, the higher the interest rate they can place someone into, that they would on the margin be incentivized to engage in that type of procedure. And you can also imagine as well that one might design an algorithm to engage in that same type of sort of evaluation of a borrower. Do you have to offer this person a rock bottom rate? And if that's the case, then we can imagine that perhaps what we're seeing, what we're picking up is it's a platform lender that is basically trying to target shopping or likeliness of competitive shopping. And that is based on some ostensibly permissible variables, such as the level of education, for instance, and that happens to be correlated with the protected classification. So if that's the case, what we would have, and this is sort of a very simplistic model of how AI and machine learning works, is that you basically are going to calibrate a model based on some target that you're searching for. And so in this example, it'd be sort of shopping ability. And then we have some set of features that are ostensibly permissible, at least they're not facially invalid, but they're redundantly encoded in the sense that they are correlated with some protected classification. And so what the problem would be is that when you train this model to find who shops, you end up using a ostensibly acceptable variable that is predictive of the desired outcome, or a feature that is predictive of the target, and the feature turns out to have this type of unintended discriminatory effect. So the question then becomes, well, what do we do about this situation? And so the first place to begin in our thinking is really to sort of try to apply this type of decision-making regime to our existing approach to unintentional discrimination, which is of course a disparate impact burden shifting framework. And what this does is it translates to testing the target and testing the features. Okay, so let's just sort of stay with the mortgage example that we have in our study. And so the first stage that you, of course, have to show in a disparate impact case is that there is, in fact, a disparate impact. Okay, so that's something that we've established just based on the sheer comparison of mean interest rates by protected classification. Second, the burden then becomes, okay, are those differences justified by business necessity? Now, here, I just want to note again, we know what that means. It means that they have to be justified by differentials in credit risk or credit worthiness across minority and non-minority borrowers. If that justification has been met, then and only then do you move to the third and final burden, which is that the plaintiff now has to show that there's an equally valid and less discriminatory practice that the lender refused to use. Okay, now I want to come back to the third burden, because I think that's the one that's being misinterpreted within the lending industry. But for the time being, I want to focus on that second burden and exactly what would it mean when it comes time to testing a model, testing its targets and testing its features. Well, the first thing to do, and what potentially may be the low-hanging fruit from a regulatory or compliance perspective, is to make sure that your target is acceptable. So in our context, if it's the case that a lender designs an algorithm to predict shopping behavior, any disparate impact is impermissible because it's not related to creditworthiness. So the very first thing every model should do is make sure that the target, if a disparate impact is happening in compliance tests or if in your investigation, make sure that the target is one that could possibly justify differences by race. It turns out that profit maximizing behavior, of course, it's made clear that that's actually not a business necessity. So in particular, in sort of the car lending and leasing cases that arose several years ago, that argument was advanced, it was rejected. Again, creditworthiness is the only target that's valid. Now, in terms of features, how do we test features? Well, the idea here is we want to make sure that the features, if they are predictive of credit risk, that they don't go above and beyond predicting credit worth. And in particular, we need to actually look at the how accurate the feature is with respecting a particular target of interest. And here, I want to go back actually to an old Title VII case, an employment case, where basically the challenge was there was a prison that was hiring guards. They basically were using a proxy of height and weight in order to sort of predict strength, which was a legitimate job required skill for this particular job. And it turned out the Supreme Court said that height and weight, it's too noisy. It turns out that it is true that height and weight is predictive of strength, but it goes above and beyond predicting that because it also predicts gender, above and beyond its ability to predict strength. So there's a statistical technique that you can use to try to decompose the extent to which strength is related to height, and then you want to test sort of the unexplained variation in strength and height across the protected classification. We document in our paper. But the point is that there is a method that maps disparate impact, the second prong of business necessity, onto statistics, and that's something that could be done to test features. Now, what I want to get to lastly before I conclude is basically the third prong. Okay, the third prong is basically the idea that is there an alternative least discriminatory model? Now, it turns out that there's a story that appears to be being told, and the Skanderson and Ritter white paper is just one such example of this. It's cited in our input accountability test paper. And basically, the general story goes as follows. It says that a lender says, well, we want to comply with fair lending law. And so we've got machine learning capabilities. We've got thousands of variables. We want to sort of see which one predicts default, credit default. So the general advice has been, well, okay, well, find the most predictive model you can. And then given a level of predictive accuracy, pick the one that has the least discriminatory effect. Right? So that's generally sort of the advice that seems to be within circulation, at least within some areas of the lending industry. Visually, we can view it as follows. Okay, so basically the way that you would sort of say, well, what's a predictive model? Is there's a question of sort of minimizing your false positive rate and maximizing your true positive rate. And so the idea is that we have this model, it's got a lot of variables, it's predicting default. So now we want to go sort of to our testing set of data, and we want to say, okay, if we set basically the acceptable default rate at this level, how many loans turn out to actually default when they were predicted to default, and how many loans actually paid off when they were predicted to default. And so the idea is that you want to minimize your false positive rate, so you want to stay on this side of the graph, and you want to maximize your true positive rate. So ideally, you want to have a curve that almost goes like this. And if that's the case, then basically you are very nearly have perfect accuracy. Okay, and that's going to be a function of where you set the threshold for what's an acceptable level of default rate. So then imagine you have a result that says, well, we have an ROC score, which is a receiver operating characteristic curve. That's sort of a fancy word of saying this curve, we want to maximize sort of the space under it. So it turns out that we can get 78% of that curve filled. So then the advice is, okay, well, for any model that is that good, pick the least discriminatory of them. Unfortunately, that is equivalent to saying that predictive accuracy is a necessary and sufficient justification for discrimination, and that is simply not the case. At least our Title VII cases say that that's not true. And so basically, I don't go into the details of this case. I mentioned it for the council's review at their leisure, but the idea here is that we have plenty of Title VII screening tests that say, well, look, you could set a threshold for, say, running a 1.5 mile run under a certain time frame. such that you have really high predictive accuracy that the person is able to, to run as fast as they might need to on the job. But if you just said more is better, more predictive accuracy is better, then you could set that cutoff at a threshold that is effectively discriminatory. Because the test isn't if it's a perfect test, it's whether or not it's a test that ensures the minimum qualifications necessary for the job. And that is the function of the last step of the disparate impact burden shifting regime. And I believe it's being misapplied, even for well-intentioned lenders that are trying to self-comply with the Fair Housing Act. And I think that would be an area that the state currently has the authority to investigate and could actually help in a way that doesn't require a lot of investment in big data, but might be able to actually move the needle in terms of minimizing the discriminatory impact of algorithmic decision-making processes.
Thank you very much, Professor Bartlett. That's very helpful, and particularly the specific suggestion that we could move forward on. Thank you very much. So I'm going to introduce our last panelist, Ziad, I hope that I pronounced that correctly, Obermeyer is the Blue Cross of California Distinguished Associate Professor of Health Policy and Management at UC Berkeley. He's a physician and researcher who works at the intersection of machine learning and health. Dr. Obermeyer is the co-author of the publications Dissecting Racial Bias in an Algorithm Used to Manage the Health of Populations and Predicting the Future, Big Data, Machine Learning, and Clinical Medicine. Thank you very much. Welcome. And go ahead, Dr. Obermeyer.
So much for having me. I'm going to share some slides, if that's okay. And what I tried to do is, in response to the questions that were sent to us, I tried to organize them into three themes. One is, what does algorithmic bias look like in health specifically? Two is, how can companies and other entities that are using algorithms avoid the kinds of biases that we discovered? And three, how should we regulate this? And I think that some of these comments might apply specifically to your department, and some of them might apply more broadly to other state and federal agencies that I've been working with on these cases. So let me start by just giving you a thumbnail sketch of some of the work that we've done to understand what algorithmic bias looks like in health. And I just wanted to flag that the method that we use to show this and a lot of our conclusions really echo what Professor Bartlett just said around this theme of what is the right target for the algorithm to be predicting, and what is the algorithm actually predicting, which is often very different. And I think that wedge between those two things is really the key to a lot of how I've started to understand algorithmic bias. So the case study that I wanted to talk through first is how health systems across the country target complex, high-need patients for extra help. So as I don't need to tell any of you, in our health system, there are patients who have these very complex chronic illnesses that they struggle with. Those patients generally get poor care because it's fragmented across lots of different doctors, ERs, hospitalizations, and they generate high costs for the healthcare system. And so across the country and across the world, health systems have been investing in what are called high-risk care management programs or care coordination programs. The way I think about these things is basically like a VIP program for people with these complex health needs. There's a single phone number that they call. There's a staff of trained nurses that will come and do home visits and get them a primary care appointment when they need it. And these things are tremendously helpful for these complex patients. The problem is, as you can imagine, those programs are themselves expensive, and so we can't do that for everyone. And so you have to target that to patients who need it the most. And this is a very common theme where algorithms are used everywhere, is when we have a scarce resource like credit, like health care, like anything else, when we want to distribute it to the in the most efficient way possible. Just to give you a sense of scale, we studied one piece of software made by one company that is being used for medical decision-making for 70 million patients every year. The family of algorithms that work like this are used for effectively the majority of the US population. So the scale at which these algorithms are being used in the healthcare system is just immense. And the way that the algorithm we studied worked and the ones that we've studied since then and follow-on work is that they want to find patients who are going to get sick, these complex patients whose health is going to spiral out of control. The way they measure that is they look into the future to see who's going to get sick. but you need to measure that somehow. We don't have a variable in our data sets called going to get sick. You need to choose a variable, and the variable that they chose is future healthcare costs. So they look into the future over the next year. They predict who's going to cost our healthcare system a lot of money, and they take the highest predicted risk people, in other words, highest predicted cost people, and they prioritize those people to give them this extra help program. So we were interested in studying racial bias in that algorithm. And to study it, you really need to define it. And this is where I think Professor Bartlett and I are using basically the same framework, which is to say, okay, the algorithm is generating a score for a bunch of people. So we studied one primary care population at one big hospital system. When it generates a score, those people at the same score level get treated the same way. So if they're in the high priority group, they're enrolled in these programs. If they're low priority, they get screened out. So they're just treated very similarly based on the algorithm score. And so those two people at the same score should have the same need for the thing that we're targeting with that algorithm score, this extra help program, irrespective of the color of their skin. But that is not what we found. So I apologize for showing a graph, but let me just talk you through it. On the x-axis, so along the horizontal axis, this is, imagine all these patients in the primary care population lined up from very low risk at 0 to very high risk at 100. So they're all waiting in line, and they're trying to get into this top 2 to 3% of the population that gets fast-tracked into the extra help program. On the y-axis, we follow those patients along, and we see what happens to their health over that next year. So if they have a visit for emphysema or an ER visit for heart failure, we just say +1. We count up all of these health problems that have flared up over that year. And we do that separately for Black patients on the top line and white patients on the bottom line. And this is self-identified ethnic background. What you can see is that at any algorithm score, no matter where you slice it, if you draw a vertical line, the Black patients are worse than the white patients. So they're at the same algorithm score. The Black patients go on to have worse health. And to give you a sense of the scale of this bias, I can tell you about this. The top 2-3% of people, these are people who are prioritized for this extra help program. Today, that program is 18% Black. Now, you might look at that and say, oh, 18%, that's actually more than the population rate of Black patients in this primary care population, is only 12%. So you might look at that and you might say, oh, great, the algorithm is overrepresenting Black patients in this high priority group. How could it be biased? In fact, if you addressed the true differences in health needs between Black and white patients, that high priority group would have been about half Black. So the magnitude of this bias is actually really, really large. And to understand where this came from, we want to know how the bias got into the algorithm and where it went wrong. We started by looking at where it went right. So this graph shows you now, again, the same thing on the horizontal axis. People are lined up in order of their algorithm score. But now on the y-axis, I'm showing you the cost, the thing that the algorithm was trained to predict. And what you can see is that those lines are right on top of each other now. So the algorithm is predicting cost very well, and it's predicting cost in an unbiased way for Black and white patients alike. So it's doing a great job answering the question that we asked it. The problem is that in predicting cost accurately, it is biased for health. And that's because Black and white patients don't have the same relationship between health and costs. And that's for two main reasons. One is that white patients on average have better access to the healthcare system. So these patients are all insured. So this isn't about insurance. This is even within an insured group. Transportation, getting time off of work, family support, childcare, all of these things disproportionately impact Black patients and mean that when they need healthcare, they don't get it. And that generates lower costs, even when their needs are just as high. The second reason, of course, is that the healthcare system just treats Black patients differently. We know from lots of studies that they are recommended for fewer tests, procedures, things like that. That also reduces cost at a given level of need. So basically, at the same level of health, Black patients have lower costs, which means that when you train an algorithm to predict cost, you are also training it by construction to be biased in its prediction of health. So you can see some of the echoes from the work that Professor Bartlett was presenting, which is that at a given level of creditworthiness, Black customers were charged different interest rates, and we're following the exact same playbook. So here are the lessons that we took away from this work. getting that target variable for the algorithm right is incredibly important, and yet it's often done as an afterthought by data science teams that are just building an algorithm and choosing a variable in a data set. When they choose a proxy, that can be discriminatory, but critically, that proxy is not part of the business necessity of the algorithm. We wanted this algorithm to find people with high health needs. We measured that with health costs. That's not about the business purpose of the algorithm. That's just the wrong choice for how to train the algorithm. We took advantage of some of the media attention that we got from the study to do a lot of follow-on work in health. We've done that with other health systems, with insurance companies, with tech companies building algorithms, and with regulators at the state and federal level. And we've found very widespread bias. In fact, the federal government's funding to the healthcare system under the CARES Act, $175 billion, allocated funding to hospitals based on the revenue that they booked the year before COVID, thereby inducing the exact same bias in federal funding for hospitals that we found in the algorithm. Not going to hospitals with high needs from COVID, going to hospitals with high revenue before COVID. That was just a choice. That wasn't part of the legislation. That was an implementation choice for how a federal agency turned Congress's intention into a proxy measure that introduced bias. Notice this mechanism is very similar to a lot of other fields. We want algorithms in criminal justice to measure someone's risk of committing a crime, but we don't measure someone's intrinsic propensity for crime. We measure a variable called arrests or convictions. We want good employees and good tenants, but what do we actually have? We have other employees' ratings of those employees, which we know is subject to lots of biases based on gender, based on age. We want creditworthiness, but what we have is income. So all of those things are very concerning and cause for, for us to be very worried about this. But in our work, we've also found that these algorithms are fixable. And in fact, it's a lot easier to fix a biased algorithm than it is to fix a biased human. So in the first case that we talked about with this algorithm that was allocating extra help to patients in the healthcare system, we worked with the company that built that algorithm, and we, in their same data set, using their same machine learning pipeline, we built an algorithm that was 84% less biased by the measure that they chose to use. And we've had similar results with our health systems partners since then. So let me close by addressing the two practical questions that you asked. How can companies and other entities avoid this? We've turned our work with all of these companies and regulators over the past few years into a playbook that we're just going to publish and kind of make public for how companies can avoid these kinds of biases. The first solution is that they have to inventory the algorithms that are actually operating, and there's no central place for companies. There's no leadership for who is using algorithms. They're done in a very ad hoc way across the business. So the first step is just to create that list of what are the algorithms that are being used. The second is to measure this label choice bias. And even though, in the literature, there are so many different kinds of biases, there's this whole taxonomy of different kinds of biases, I think of this as an organizing principle that helps us see all of those different kinds of biases, because it compares the business purpose of the algorithm with what the algorithm actually does and illustrates where those two things are different. And we found this to be a very powerful organizing framework for surfacing biased algorithms in our own work. And the third step, of course, is to fix or delete the biased algorithms. And I'll just note that once you've shown that there is bias, so in our case, we showed that patients at the same algorithm score went on to have worse health. Health is the key to fixing that algorithm, because now we can retrain an algorithm to predict health instead of cost. So demonstrating label choice bias is also the key to fixing it, because you've already shown where the bias is, and now you just need to train the algorithm to predict that thing. So I don't think this is true in 100% of the cases, but we've found it to be true in almost every situation that we've worked in. Finally, how should we regulate this? And what can you do? So the first thing I'll say is that, just based on what I know from the follow-up from our study, the New York State insurance regulator, Cory Booker and Ron Wyden, the Federal Trade Commission, have all started to take this seriously and to try to hold organizations accountable, but more importantly, to actually provide guidance to industry. You guys cannot be everywhere. And the innovation in the sector is proceeding so quickly that it's much better to prevent this than to fix it. So I think that there's just a huge opportunity for you as a department to provide guidance to industry on what bias looks like. How do I inventory my algorithms? How do I measure biases? How do I fix them? In my work, one of the concerns that often comes up from the legal teams at companies is like, well, we don't want to do this work because then it'll be clear to a regulator that we knew about the bias and then they can hold us accountable. And I think the message that I've gotten from all of my conversations with state attorneys general is that that ignorance is not going to protect you down the line. And in fact, it's much better to know about these things and to proactively fix them than it is to wait for a regulator to begin an investigation into your product. And so I think that making that well known, if you agree with that perspective, would be really, really important in giving legal teams permission to allow this kind of work to take place within companies. Finally, one thing we found is that the state of record keeping on algorithms within companies is shockingly bad. People are making ad hoc changes based on heuristics. They're never writing down what they're doing. When we ask a company in the course of an investigation, why does the algorithm work this way? They say, oh, yeah, Bob, who worked with us 4 years ago, made that change and we don't really know why. And this is like, I think, a big problem. So making sure that the standards of record keeping that we expect of companies and lots of other places are upheld here seems very important. And finally, I think, there are lots of cases where existing civil rights law and fair credit reporting and opportunity laws can apply to show that algorithms are in fact biased by comparing the proxy or the algorithm score to the true measure of health needs or loan repayment rates or creditworthiness in the same way that I think we just saw from the previous presentation. And I wanted to make one last point, which is that the way we think about this and the way we've diagnosed and fixed bias doesn't require us to open up the black box. We don't need explainability. We have the score, and the score gets compared to another measure. And so we can do this in a way that preserves trade secrecy and in fact doesn't require us to explain or understand the algorithms just to see the algorithm score. So I'll stop there and thank you very much.
Thank you so much for all our expert panelists. I'm going to open it up for questions that council members may have. Councilmember Iglesias, go ahead, followed by Councilmember Brodsky.
Thank you very much to all the presenters. Under FEHA's regulations, under disparate impact, the burden of proof to show the least discriminatory alternative is on the defendant. And I'm wondering if that might make much difference, or if we could use that. I'm particularly thinking of, well, all of you who discussed disparate impact, whether that burden being on the defendant, that they have to prove that they're using the least discriminatory alternative, to what degree can that be helpful?
Well, since I raised the issue, maybe I'll take a stab at it. So I think it's obviously incredibly helpful if you observe disparate impact and you're concerned about having companies evade discriminatory practices because of that prong. The issue that I just really would like to try to get more airtime is what it means to establish to meet that criteria, regardless of who bears the burden. Because I do think that there's a misapplication of it in the context of AI, where predictive accuracy has sort of taken over as basically satisfying that standard. And you see a bit of it in HUD's revised rules with respect to disparate impact liability under the Fair Housing Act, where it seems as if predictive accuracy, if you can just show that it's an accurate model, then that's going to basically be sufficient to justify it. And I think what I would suggest is if you go back to the burden shifting system in the Title VII context, it's very clear that the courts have said that no, it's the minimum. You need to show that first, what's the minimum standard that you're trying to achieve, the minimal acceptable standard, and then you go from there to find the most accurate model. So in the context of lending, for instance, there would be some obligation of the lender to offer up what is the minimum default rate that you're willing to accept. Now I'm sure they would be open to justifying that for whatever business reasons, but they need to at least establish this is the minimum default rate. And then having established that, this is the most predictive model with the least discriminatory impact.
Just to add to the great points that Bob made right now, I'd also point to CFPB's no action letter, their environment that they created to encourage innovation in fintech. But it was one that was more of an iterative, I won't say entirely collaborative process, but where actually it builds on this notion of being able to truly, again, explain why this is the, you have a legitimate, why this is the least discriminatory alternative, and to begin to speak to some of the statistical considerations Bob was raising about what is the reasonable rate of return, how much should that be considered within this space, and reasonable to whom? And because our notions of reasonableness in terms of rates of return have also been shifting, right? We have the Military Lending Act, which imposed a 36% rate cap nationally, which is still a gigantic rate cap, but looks tiny in comparison to 400% interest on a payday loan. We have our bill in our state that also established 36% as a cap. I mean, so it's shifting, which you can see in the evolution of fair housing law nationally. There's an opportunity here to make a positive impact in terms of how we think about it and how you think about it as a regulator, what you're going to require. I think there's room within that space with the burden shift of requiring more, not less.
Councilmember Brodsky.
I have two sort of probably unrelated questions. The first has to do with, it keeps occurring to me that in our regulations right now with respect to disability discrimination, that especially in the context of reasonable accommodation, an individualized assessment is required. And what I keep hearing, I mean, in the use of algorithms is the absence of that. And I'm wondering if there's a way to incorporate that concept into how we fend off this, or how we change how we look at the use of algorithms. And then the second thing is just a quick question for Dr. Obermeyer. I'm curious, when you change the target from the higher costs, what did you change the target to?
I can just answer that last one quickly, which is that one of the problems, I think, in lots of these areas where we're applying algorithms to complex social questions like health or crime or labor is that the underlying quantity of interest is actually very hard to measure. So there's no variable called health. Health is, of course, its own multidimensional concept. And so the way that we've approached this in lots of different settings is to just embrace that multidimensionality, which means doing a lot of annoying data work to merge together a lot of variables. And so, you might want to measure diabetes with a laboratory study called hemoglobin A1C that measures diabetes. And that's great, but not everyone has that. So what do you do with the missing values? Well, that brings up its own set of questions. So you have to stitch together a lot of different variables and then use the kind of knowledge of how that data gets generated. The fact that doctors don't test some people for a reason, but they also misdiagnose other people. Anyway, so if you stitch together a lot of variables, you can come up with some multidimensional approximation that's much closer to health, at least, than cost is. I don't think we've solved all these problems, but we're at least making it better.
Thank you.
I think your question gets to the key issue because it comes up in the context of lending too, character. Who's going to make the determination? Go ahead. That could be, so totally relevant to what you've been working on, Eric, also, absolutely. This seemed like a good idea, I think you said. This seemed like a standard, normal idea, I think you were saying, in the context of tenant screening. There is squishiness to be had across these various arenas. And I think a question that I don't have an answer to is how we leverage the good parts of this technology while maintaining also the good parts of some human ability to assess the squishy bits that may require such vast quantities of data, again, without that we might spend the next 50 years trying to figure out if we can data our way to a reasonable, rational conclusion on a consistent basis, all while our society evolves during that time period. It's a shifting, some of that is shifting ground. And so anyway, some thoughts.
Thank you. Councilman, go ahead. Mr. Dunn.
I was just going to add on the idea of doing an individualized assessment is something that I think it really did start with the reasonable accommodation context where, housing providers may even be required to engage in some kind of good faith dialogue when somebody claims that they're either being denied housing because of reasons related to a disability or housing's not working for them for some reason. And of course, the HUD 2016 guidance on the use of criminal records in rental admissions requires an individualized assessment before someone's denied for a criminal record. We don't always see perfect compliance with that requirement, but that is what the guidance says. And so it's something that housing providers should be in the habit of already doing. There's really no reason why that can't be expanded to other types of situations where somebody's denied housing based on a computer model or based on an automated report. To then say, okay, well, you've got a denial recommendation. Looks like it's based on, you owed money to a past landlord or whatever. Is there some reason, that something else you want to tell us before we deny your application and have that be considered? So it's not asking for a lot. And I think where a lot of this comes from in the tenant screening context is you have these screening companies out there saying, if you do individualized assessments, if you have individuals making decisions on who to rent to, then you're going to get sued for discrimination because you're going to have one property manager that's going to let somebody in and then somebody else is going to apply and has similar information and be turned down. And then somebody's going to, somehow say you're discriminating. And that's just not the reality. If housing providers are making good faith decisions about, who they think, can afford the rent and comply with the rules, that's not going to happen. And you can train people not to discriminate and hire employees that aren't inclined to discriminate. But when you turn everything over to computers and you apply these rigid criteria and treat everybody, as a statistic and as a number, then you are going to engage in discrimination. You are going to open yourself up to housing discrimination claims when people are able to show that, well, hey, when this policy is disproportionately excluding members of this protected class or that protected class, and you don't have any evidence to justify it.
Thank you, Mr. Dunn. We're going to go next to Councilmember Schur. And for members of the public, we're going to provide an opportunity for you to provide comments. Please raise your hands in the interim, and we will call on you. Councilmember Schur.
Hello, thank you to the great presentations to everybody. I'm wondering, we've talked some about affirmatively furthering fair housing in both the lending and the housing context. And was recalling some presentations I'd heard about the effect of algorithm bias in housing screening and housing searches. And it seems like some of the things we're talking about are second level effects. If people are being steered to bad neighborhoods because of algorithms and what rental opportunities they're being shown or what housing opportunities they're being shown, or if the loans are happening in certain traditional redlining increase because of algorithm bias, then that has a cascading effect, I think. And I've heard some testimony in another panel about it starts as, when you do a Google search for an apartment and you might get steered to a different neighborhood or a different set of apartments based on your browsing history. And I don't know if folks have thought about how those layer together and how we address that.
Definitely thought about it and raised it, thanks, Dara, at the end of my remarks, because I was just too long-winded in trying in actually speaking. But advertising, it starts right there. It absolutely starts with the initial search. And I've also was thinking about discrimination in collections on the back end as well, because of the iterative effect on credit and yada yada, which came up, for example, in a mortgage servicing case some years ago where and I think finally on maybe the third iteration of the complaint, they got past the motion to dismiss stage. But there was a particular servicer that bought a pool of mortgages that was predominantly a pool of people of color, and they were processing those mortgages. They were doing collections differently than they were doing on the other, as to the other pools that were not predominantly people of color. So that's, in my little universe, that was one of the examples that just sticks in my mind about like, it's an ecosystem of badness. It's an ecosystem of problems. But advertising across the board, whether it's looking for rental housing or looking for a loan or looking for insurance or looking for medical services, seems like a really important place to be able, which draw information from, which suggests also, to the extent that social media platforms are being used for the dissemination of information, maybe just draws you into a broader arena of folks to regulate. And I think you should.
Yeah, I know one issue that's caused problems is some of the websites that are used to basically determine like what rental advertisements to show people are based on the geographic location of the person who's browsing. And so apartment ads that are within so many miles of where the person's located are going to be tagged and come up in the person's feed. Well, you know, when you think about if we have neighborhoods that are already, you know, racially or ethnically segregated, and then advertisements for new housing being generated based on where you're already living, it reinforces patterns of existing segregation. So, you know, people should be able to move to whatever part of town they want to live in, but if they're only seeing ads for the area where they're already located, then maybe they're more likely to, you know, only look in those areas. So that's one iteration I've heard of this problem. Another is there's a particular website that sort of matches people searching for housing with landlords looking for tenants, and it has a menu of options where you can check like, do you want housing, you know, with these features and these conditions, and then landlords, you know, will you accept tenants with these criteria? And I understand that this has been removed from that site in particular, but one of the things that landlords could click a box, do you accept Section 8 vouchers? And so a lot of landlords would just click the box, no, you don't. And so tenants that are searching for housing would never see ads from that landlord if they put in that they had a Section 8 voucher. And so I think there are just myriad ways that these types of things can result in discrimination.
Thank you. Go ahead,
Oh,
Professor.
sorry, just one last point. The data describe the world as it is, not the world as it should be. And yet within the data, you can actually try to back out what it would look like. So instead of just building algorithms that advertise based on where people do live now, in your data set, you probably have something like, if I showed someone from this zip code an advertisement in this other zip code where there aren't people from your zip code, would you be interested in that? And so there are ways to kind of work around these things, but you do have to be thoughtful in how you specify what the actual target is for the algorithm in order to not reinforce these kinds of biases relating to the inequalities in the world as it currently is.
Thank you. Thank you. Kara Botcher, do you have any public comment?
We have one hand raised, Merv Highcock. I'm going to go ahead and unmute you now.
Okay, and just to let everybody know, there's 2 minutes in terms of public comments, so go right ahead, Mr. Hickok.
Mr. Hickok, thank you so much. At least in the employment settings, responsibility and liability sits with employers, which doesn't put any burden on vendors to prove that their algorithms do not use pseudoscience, that their outcomes are fair, or even the proxies or the features that they use are related to job requirements. Some of you might have known that EU just proposed a regulation requiring vendors to put in writing details of their systems, the intended purpose of the system, quality of data sets, features used, functions optimized, or even risks that are foreseen and the mitigation methods. Does the state, or do you see any, either within the state or federal level, see any similar approach on putting similar burdens and similar amount of liability and responsibility on the vendors.
Thank you.
I can just weigh in.
Any of the presenters or Ms. Brown or Mr. Dunn, have you seen nationally or in states efforts to address the creation of algorithms that may be having a disparate impact on the front end to ensure that there's more transparency, disclosure from these entities to see what in fact they are using as variables in making these determinations? Any movement on that front?
The only thing I've seen, sorry. The only thing I've seen related to that, there was a bill that didn't make it out of its first committee hearing in Maryland, but Maryland has a state agency that basically has the ability to define certain terms and sort of sub-regulate consumer reporting agencies to some extent. They're primarily regulated under a federal statute, and anything new the state does often difficult to steer around preemption. But this bill would have enabled their state agency to define the disclosure requirements under the Federal Fair Credit Reporting Act in such a way that the companies would have had to disclose enough information that you could figure out how the screening company chose the date that they assigned to your record, or which crime category they put it in, or how it was filtered, so that you could figure out whether some kind of mistake or error was made in applying the landlord's rental criteria to an application. So I think it's possible that other states might try to do something like that, or that the Maryland's bill might move in a future session, but that's the only thing I'm aware of.
I'd just like to add for folks something that I mentioned in the last panel, which is that our state anti-discrimination law that covers employment and housing already has an aiding and abetting statute or provision. That provision is largely untested in the courts, but we at DFEH have seen cases in the employment context of employers using tools or technologies developed by other companies that have that discriminate. And so we've seen this come up in the disability context. If an employer is using a particular tool for which no reasonable accommodation has been developed by the developer, that potentially the developer, and this would be very fact dependent, but potentially the companies that are developing the tools could in some circumstances be brought into the solution, whether that's a legal case or not. So there is an existing tool, but the contours of that tool are largely unknown at this time, at least as interpreted by courts.
Thank you, Director Kish. I know we're over time. Should we have time for a couple more questions?
We don't have any other hands raised, but if the council members or other panelists may have questions, we could take them.
There's a council member who has any questions or further comments? Okay, Councilmember Iglesias. You're on mute, Mr. Iglesias, Councilmember Iglesias.
Thanks very much. Just again, a quick thank you to all the panelists in this section, and then also just encourage people in terms of follow-up that we could provide to you our particular regulations, and you might be able to provide particular suggestions for modifying them. So for example, Eric, I'm not sure if you've seen our criminal history regs on housing, and maybe we didn't have this in mind when we were drafting those, and maybe they could be improved based on this perspective. So anyway, thank you all very much.
Thank you.
Great, I think we have no further questions. I want to thank again all the panelists today for this very informative civil rights hearing on algorithms and bias. I want to also remind those individuals who are members of the public who are attorneys, please ensure you send an email with your state bar number so that you could provide my colleagues with that information so that you in turn will get your credit. I want to again thank you for everyone for participating in today's hearing. And without any additional information, I wish everyone a very good afternoon. Thank you so much.
Thank you, and thanks to the people on the DFEH staff and the council who put this wonderful hearing together. Thank you.
Absolutely. Goodbye.